The jury will not be sequestered.
I'm Brian Buckmeyer, along with Terry Austin.
In the Weinstein case, fellow silence breakers and any...
Jury selection is moving along
Well,
here.
I'll read the verdict, says the Jesse Weber. Thanks for joining us.
We don't tend to see it as raw as this.
Good evening and welcome.
Welcome to Law and Crimes for the Record. A very happy and blessed New Year to you all. Thank you so much always for your support at the Capital Gavel coverage here at the Law and Crime Network. And we have a lot on the plate today, and I mean a lot. Let's start off with Wisconsin versus Chandler Halderson. This is a kidnapping, killing, and dismembering of his parents. This case is in jury selection, and we were going to be giving this to you gavel to gavel. It is really a horrific case. Question is, did the defendant do it? We'll find out as the trial progresses. In Florida versus Dayonte Resiles is a retrial. The first trial is a murder case. It's a death penalty case out of Florida. And the first trial actually resulted in a verdict. But when the judge was polling the jurors, the foreperson of the jury said, wait a second, I can't go along with this manslaughter conviction, sent the jury back into the jury room, declared a mistrial eventually. So this trial is being tried again. The defense tried to say, wait a minute, double jeopardy, double jeopardy. He shouldn't be in jeopardy of having the same charge tried twice, but no way, because the jury's verdict was not finalized. So he will be facing the full boat of charges for that 2014 killing of 59-year-old Jill Halliburton. And we also have Colorado versus Rogel Aguilera-Mederos. He was the first person, a truck driver, who received a 110-year sentence, you may recall, for a vehicular manslaughter conviction. An outrage went across the country. Millions of people signing a petition saying, wait a second, 110 years, people that commit murders don't get that kind of sentence. And actually, the sentence was eventually reduced based on that public outcry to a 10-year sentence, which is obviously something that's much more proportionate to the crime that he was convicted of. We also have updates on Colleen Maxwell, a guilty verdict last week out of 5 of the 6 counts. Big question. Defense says they're appealing. Is there any legitimacy to this appeal? We're going to try that out with our expert panel that we have here. I pretty much think that she's done as far as that's concerned, but these are serious convictions for Colleen Maxwell, a clear win for the prosecution. Elizabeth Holmes, we are on jury verdict watch. Elizabeth Holmes from Theranos, the company where she is accused of having defrauded patients and doctors and investors, was once considered a rising star, a billionaire female in Silicon Valley, now facing her fate. There's been 6 days of deliberation. This jury has not come back on whether or not the government has proven its charges. We'll be following that for you as well. We also have Wisconsin versus Edgecombe. This is another case that was supposed to start this week for jury selection, another murder trial that we were going to cover here. But unfortunately, like it goes on in a courtroom, it is delayed because the judge has COVID. So that jury selection will recommence January 18th of this year. And then lastly, we have Crystal Daniels, the mother of baby Joe. You may remember we covered that case when the father was tried. Baby Joe has been missing since 2018. She is charged with aggravated abuse. The husband had been convicted of his trial, serving now a 51-year sentence. So let's go back to Chandler Halderson with regard to the bail hearing here. Again, this is the individual accused of dismembering his parents. There was a bail hearing in the summer. $1 million bond was set. I apologize. Let's look back at the defense argument with regard to that bail hearing.
So he's had no meaningful opportunity whatsoever to post bail since his arrest on the 8th of July, because the minute we got a bail that was reasonable, the state immediately put another hold on him for the charges they were already investigating. I would note that almost the entirety of this criminal complaint talks about investigation and activities that would have predated that July 12th initial appearance date. And so I have to pose the question, why did it take so long? Why was he held in jail this long without any meaningful access to bail? But pivoting away from maybe what some might consider, technical legal arguments that may or may not have merit, depending on your point of view, I would reiterate what I said on the 12th, which is Mr. Chandler Halderson, sits here today with no prior record, a lifelong resident of the state, a high school graduate involved in many activities, such as Boy Scouts, church groups, school activities, the things that show he's been a problem-free part of this state and this community. Moreover, Mr. Halderson would agree to conditions such as electronic monitoring, the curfew as suggested by the state, whatever the court would deem appropriate.
It's hard to overstate the importance of bail hearings, especially for the defense. Very difficult to defend a client that's in the jail for such a multitude of reasons. So these are very, very important proceedings. Let's listen to a little bit of how the prosecutor responded to this bail hearing.
There is in the criminal complaint, unlike what Ms. Doral said, there's a lot of references to things that happened on the 13th and the 14th after the IA on Monday. Additionally, Monday's hearing was only on the charge of false reports of missing persons. It was not on homicide. It was not on mutilating a corpse. It was not on hiding a corpse. And this is a ongoing case. Ms. Doral brings up Boy Scouts, and she harped on him being an Eagle Scout at length on Monday. Well, in this case, you're going to learn that there is evidence of rope and knots being tied, such that an Eagle Scout might do. And the fact that he has no prior record, although relevant, also is overshadowed by the fact that he has now entered the criminal justice system with a bang. These are the most serious charges that anyone can be charged with, and frankly, we expect more. Thank you.
All right, so we got a great crew with us today. We'll start with Karen Felecia Nance, who is a criminal defense attorney, an investigator, a child advocate. I was doing a lot of reading on you. Stilettos 60, I love it. I love your inspirational messages, Karen. So welcome to the show. And Bob Hille, the famous Bob Hille, is a trial attorney and has a coveted distinction of having been a former president of the New Jersey State Bar Association. You don't get there unless you're the real deal, and have a lot of respect from the lawyers throughout the state. So we have two great guests with us today. Karen, let me start with you a little bit. These bail hearings, talk to us about the importance of them in terms of representing a client from the defense perspective, but by the same token, the prosecutor's role in making sure that people are not out on the street who could be a continuing danger to the community.
As a defense attorney, it's extremely difficult to represent a client that is incarcerated because you have to get into the jail. And with COVID, I'm sure that there's a lot of challenges with that, in addition to the privacy issues and actually having physical access to the client, which is obviously going to be extremely limited with them being incarcerated. So that's from the defense perspective. From the prosecution's perspective, we want to make sure that this person's not going to flee the jurisdiction and evade the trial process. And so we want to make sure that the bail is set at such a rate where the person is not going to flee based on the amount of bail that's set. But in this particular case, he's probably not going to be able to post the bail. He hasn't been able to do so. So I think that we weigh both sides. And even though it's going to be difficult from the defense perspective to adequately represent their client when they're incarcerated, it's probably based on the charges, as the prosecution pointed out, you need to have this person secured so that they're not going to flee the jurisdiction. So I think that the bail, setting a very high bail, is very appropriate in this case.
Yeah, Bob, you know, there's a lot of controversy going on out there, and I'm listening to it. It kind of, I understand it from the public point of view, but there's a balancing act, and a one size doesn't fit all. When I became the county prosecutor, we had people in jail that were waiting for trial for 3 and 4 years that couldn't make a $200 bail on minor crimes, which was more time than they would serve if they had actually been convicted. You know, we had to reverse that situation. But by the same token, we have bail reform laws in some states that don't even take into consideration anymore the danger that the defendant poses to the community, which I think is absurd. What's happening out there, Bob, in your mind, and where can we get it straight where we have a more balanced approach that lets the lower level offenders out, but by the people that do things like this, we make sure that they're not a continuing danger to the community and that they stay in? Thoughts?
Well, yeah, I mean, the federal system, or the U.S. Constitution, has the Eighth Amendment that says, you know, presumptively every defendant is entitled to non-excessive bail, which has been construed under certain circumstances, that there's an entitlement to bail unless there's some countervailing risks, such as obviously bail is designed to ensure the attendance of the defendant. Bail needs to take into account, as you said, flight risk, threat to the public, but also threat to the witnesses and the evidence in the case, because sometimes people get out. Now, on the flip side of that, when they're incarcerated, not only does it limit client access and privacy issues, puts those at risk, but your client is in danger of making or having interactions with jailhouse snitches that all of a sudden may creep their way into a case. As we saw in the Durst case, they're writing letters out to other friends, and those things can then be subject to, possession by law enforcement and used against a defendant. So, what are they doing out there? In New Jersey, for instance, they changed the Constitution. They said that, bail is not an issue anymore. You look at the crime, the offenses, the nature of it, the defendant, and you have these standards. New York has done a similar type of thing, but they're having some problems in terms of some of the overreaching or across the board scope of when somebody can be released. So, I mean, these things are still being wrestled with because, as you said, there is the bail system, which has been in effect for almost 200 years across the country, or more than 200 years across the country, that has inequities as a result of that. And these types of reform measures are trying to level the playing field. Whether they can do that or not, who knows,
Yeah, having any kind of bail reform without taking into consideration the nature of the crime, especially a violent crime, and their danger to the community, to me, which is what some states, I believe, New York is still doing, is lunacy in my mind. Nevertheless, we have Sarah Gillespie, who's a reporter at the Law and Crime Network, is reporting to us on another very important thing when you commence a trial, and that's jury selection. Your jury is so important. 3 jurors were dismissed, supposedly because they knew too much about the case. She may come on later on in the program, but nevertheless, they were stricken by the judge. Let's listen to the court's ruling on that.
The factors in favor of significant cash bail are certainly the nature of the crime. It's gruesome, it's violent. The potential penalties are significant, mandatory minimum prison for 20 years. And I reviewed it relatively quickly, but I also reviewed the PC affidavit for when the additional charges were lodged, which went into some of the lies by Mr. Halderson and attempts to cover things up. I think he's got a lot of incentive to not appear in court now that he is finally charged with first-degree intentional homicide and the other charges. And as far as circumstantial cases go, it appears to be it appears that there's some fairly strong evidence given the observations of Mr. Halderson in and around the home where the body was located, the lies that were told to law enforcement and others, the observations of his body, the statements in regards to all sorts of blood on him, but no injuries that would be consistent with somebody having all sorts of blood. So there's also, I think, a strong case, even though we don't have a direct eyewitness saying he committed this offense. I don't know whether he's going to be charged with additional charges, and I'm one who is always reticent to factor those in because I don't know whether that's going to happen. I don't think that's fair when assessing bail to assume that somebody's going to get charged with some other stuff. And that's, I guess, why it makes sense that the commissioner at the earlier hearing didn't take that into account, because you just don't know. And you don't even know if there's probable cause, really, unless somebody reduces it to writing an affidavit. But things have changed greatly since that bail hearing. I am going to set $1 million cash bail. There's just too many years at stake in prison for Mr. Halderson. I am going to also order pretrial services if released, so he needs to contact them immediately upon his release. If they don't answer the phone when that happens, you need to be providing them your phone number, your name and case number, and respond to that when contacted. Although given the nature of the case, maybe there'll be some stuff behind the scenes if bail were to be posted. So pretrial services has a heads up on that.
Okay, Bob, that wasn't about jurors being dismissed, but it was a continuation of the bail motion. So there are arguments going on. Did the judge get it right in denying this motion by the defense?
Looked at all the things, that the judge is supposed to look at, and he made a judgment call as they're required to do. So is it right or wrong? I mean, that'll be subject to an appellate court at some point in time. But if he's really concerned this person is a flight risk, then he's going to want to set a number that if somebody's going to post that or vouch for this individual, they're going to make sure this person, shows up again. So, it's interesting to see where that's going to go, but I think it's probably going to stick. I mean, they can seek an appeal now and try and reduce it in the appellate division or the appellate courts of that state, but at least at this level, doesn't look likely that that's going to change.
Karen, talk to me about alternatives. In the old days, you had two choices: you were in or you were out. The idea of raising the bail because of the seriousness of the charges stems from the idea in the case law that you have a greater risk of flight if the charges against you and the penalties against you are more severe. But with today's electronic monitoring and other things, are there alternatives that we could explore so that you both preserve the defendant's right to a constitutional bail that's reasonable, or conditions that are reasonable, allowing the defense to have access to them, and at the same time protect the community?
Absolutely. We have electronic monitoring. We've had it for quite some time. And so that comes at a cost to the defendant as well. So financial ability is also an issue, but not clearly to the extent that having to put up $1 million bail. And I think that the electronic monitoring system has shown to work. I don't think that there are too many cases where people have been sent home. It's house arrest, basically, right, where they're told to be monitored for 24 hours every day for a period of time. And if they violate that, then they go into prison, go into custody. So it's a protection in that it makes sure that we can keep an eye on these the people that are accused that are out. And then at the same time, if there is a violation, if they take the bracelet off or they violate the home arrest, they can be then remanded back into custody. So I think there's a safeguard that's less costly and also ensures that the defendant will appear in court for trial.
Okay, great, guys. All right, we're going to take a quick break on here for the record, but we got a lot on the plate, as we indicated before. A lot of interesting trials. We'll be covering gavel to gavel here. Happy New Year to you all. Wow, it's going to be a great 2022. We really do appreciate you supporting and watching us here at the Long Crime Network. We'll be right back.
My Just Fab fall collection is high on style. Think runway fashion without the price and wear all day comfort. This is the return of fabulous fashion. Step up, step out, you're on.
My leg hair was coarse enough to braid, and this razor sailed right through it. I'm like a naked dolphin. Yes, I know. Dolphins are already naked.
No one can deliver your mom's homemade short ribs. That's why Instacart helps deliver the ingredients, and you add the love. Visit instacart.com or download the app to get free delivery on your first order.
My finances are very out of control.
Having a family and the finances, it's a tough balancing act.
You're sitting here at the end of the month looking at all the bills thinking there's got to be a better way.
Introducing the NetSpend Prepaid MasterCard. There's no credit check and no cost to order.
I dedicate my life to helping people achieve their potential and discover the tools to make that happen. That's why I'm excited to tell you about the NetSpend Prepaid MasterCard. This, my friends, is more than just a card. Use it anywhere debit MasterCard is accepted. You can use it to shop online, pay bills, buy gas. And get this, with NetSpend and direct deposit, you could get paid up to 2 days earlier. Just think about how much that could help.
My coworkers are always like, how do you have your check already? I'm like, that's because I use NetSpend.
Even better, you can earn cashback rewards on many of your purchases.
That money goes right back into my account, and I love it.
With NetSpend and direct deposit, your paycheck or benefits check loads into your card account. No more standing in check cashing lines or running to the bank or waiting by the mailbox. Each time you make a purchase, you get a text that shows the amount and your new balance. Netspend's mobile app is so convenient and puts your money at your fingertips wherever you are. You can even send or receive money from friends and family right through the app.
With the app, it's very easy to transfer money to family and friends.
There's a $10 purchase cushion in case you come up a little short. With your Netspend card, you got this.
I got this.
I got this.
With Netspend, I got this.
Call now. There's no cost to order and no credit check to start. With Netspend, you pay no interest fees, late fees, or activation fees because this is not a credit card. Don't miss out.
Order now. Be one of the first 200 callers and choose your card color. 1-800-614-9049. That's 1-800-614-9049. Get paid up to 2 days faster with Netspend.
Smart news.
I was only watching news I agreed with.
I was only getting news from social media.
Now, I use Smart News.
It has news from all sides.
I trust Smart News.
Download Smart News for free today.
I'm Terry Austin, and you're watching Law and Crime.
Welcome back to For the Record. Tennessee versus Crystal Daniels. The husband had been convicted, as I had indicated earlier, and received a 51-year sentence for felony murder for the killing of baby Joe. The mother of the child, Crystal Daniels, will be on trial next month for various charges, including aggravated abuse of a child. There was a pretrial hearing that had occurred with respect to a number of issues, but also, interestingly, a transcript of a polygraph that was taken that was mentioned during the hearing. Let's take a listen to this.
Where was the blood at?
And what was the defendant's answer?
I didn't even see any blood.
Now, if you go to page 159. And let me back you up actually to page 158, bottom of 158, line 23. Agent Boyd asked a question that continues into page 159. If you would read that question, please.
You can't remember. It was right before. Hey, let's go back to this, okay, Crystal. When JoJo said, he told you that, what did he tell you? How? He said he was going to hurt you. What did he say?
And what was the defendant's answer?
He told me if I said anything, he was going to kill me. I asked, what did he tell you? What did he tell you? She replied, he called them. Okay. Did he tell you what to say? What did he tell you to do when the sheriff got there?
And what was her answer?
To tell them that baby Joe ran away.
Okay. So, Agent Faulkner, in this particular case, the defendant is telling you she had spoken to Joseph Daniels, the co-defendant. Together they had agreed to tell law enforcement that baby Joe had run away.
Yes.
Starting with line 5, what questions did you ask of the defendant?
Okay, Crystal, when you heard baby Joe cry and you came out, did you see JoJo do anything else to him, hit him?
And what was her answer?
She replied, no, because he told me to go and he swung at me.
So 2 times in this interview, at least 2 times, the defendant has made a statement that co-defendant Joseph Daniels threatened to hit her and actually swung at her. Is that correct?
Yes, sir.
All right, Karen, how damaging are these statements that defendants make? And one, if you can, I know I'm going to ask you to get into some psychology here. Why do defendants make these statements, and why do they agree to take polygraphs? Because this is coming out from the report that was being taken, the interview that was being taken during the course of taking the polygraph, which is always done.
I believe people in their hearts believe that they are not guilty or justified in their actions, whatever those actions may be. And those that do commit crimes or do commit wrongdoings, they believe that they can beat the system, most probably, right? If I can convince others of my innocence and I can do that through a polygraph, I will do that. I think that the thought is when you're asked, do you want to take a polygraph? If I say no, then it assumes my guilt. So I'm going to go ahead and try to beat the polygraph. That's my assumption on that. And a lot of times it's best, right, not to say anything at all, to evoke your right to remain silent. But many times people that are accused or charged don't do that.
Bob, I think Karen is onto something here. I cannot tell you how many cases as a prosecutor we were able to solve on that very psychological principle. Like, hey, you know, we want to, it's your parents or it's your wife or a family member. Obviously, you want to help us out. You know, you want to do the right thing. You know, because you don't want to be a suspect, and that kind of pushes people into speaking to the police and doing things like taking polygraphs. Do you agree with that or not?
Well, and all that's fair game for law enforcement in terms of doing an investigation. Because, you know, it's only a question of when it crosses the line to be coercive, and then you don't have reliability in what the person's saying. But yeah, I mean, I think what Karen mentioned and what you just referenced concerning polygraphs are that people don't understand the presumption of innocence in that context. And most of these times I see them, they're not being consulting with a lawyer or being advised by counsel. And they go ahead and they voluntarily, you know, undergo that process, probably for the very reason, then they think that whatever the motivation is, whether they believe they're innocent or not, they're afraid that somebody's going to think they're guilty. And that's why they do it.
Yeah, and many times that becomes the piece of evidence that cinches it for the prosecution. Been there, done that. Let's listen to a little bit of the cross-examination during this hearing of the agent who actually took the statement from Crystal Dennis.
You asked her 190 questions. Okay, but your job is to do the polygraph.
And the interview is part of the polygraph.
And intertwined in the interview, you bring up several times, do you not, the polygraph?
At what point?
At many points in the transcript, you say, look, you're lying, we know you're lying, your body colors you're lying, you failed the polygraph. You told her all of that over the course of this interview.
After we told her.
And when you say we, are you?
At that point, Agent Boyd had came in before we gave her the results and told her that she did not pass the test, that she failed the test. I told her that we knew she was lying, and at that point, I don't recall that we talked to her. She brought up the polygraph another time or two. At that point, I told her we were getting away from polygraph, and I don't recall that I brought up the polygraph anymore. I do remember that she brought it up a couple times.
But if the transcript.
So, Bob, this polygraph thing can be a very valuable investigative technique. And I know there are polygraph experts for the government who are actually advised that when they see charts that show or indicate that the person is telling the truth, to confront them nevertheless and tell them that they failed the polygraph to get their reaction. And it is kind of surprising when you see it. Sometimes you see people like, this machine's not working, it can't be possible, I'm not lying, which gives the polygraph examiner an additional way of saying, well, you know what, that confirms the charts, because it's not really a scientifically reliable instrument, as opposed to sometimes people saying, yeah, I know, you guys got me. What do you think about that investigative technique using the polygraph that way?
Well, and you know, often those, I think the better examiners in the cases that, you know, I've seen, they really try and play it straight and get a clean admission of guilt or a clean measurement, because the polygraph isn't an exact science. It's ordinarily not admissible. The statements that the person's voluntarily giving would be admissible as admissions against their interest later on. But the results of whether or not they're telling the truth would not be admissible. So is that a reason for the courts to sort of give the leeway to the examiner to say, oh, you know, it shows you're lying, which is really making a misrepresentation to the witness? You know, and again, is that an entrapment? Is that coercion? You know, it's really a case-by-case basis, and it depends on the length of the examination. If the person's giving you a consistent response through, and then after 4 or 5 hours, they start to get tired, and they start to just want to get it over with, and they start to say new things, you know, that also raises issues. So I think, you know, good law enforcement techniques are good law enforcement technique, and they'll use those to be careful to get what they really need that'll stand up in a courtroom.
Well, Karen, did you catch that? Bob Hille sneaking in admission against interest, the exception to the hearsay rule, which allows an out-of-court statement to be admitted. Typically, you can't do that unless, as Bob Hille indicates, you have an exception to the hearsay rule. That's why I love having guys like you on this show. We're going to take a quick break, Karen. We're going to get back to you on the other end. We'll be right back.
I'm Dan Abrams, and you're watching Law and Crime.
Every plate helps save you time and money on meals you'll love.
We have a high-pressure system moving in from the east.
So you can seize the day. Oh, no. Even if it's not ready to be seized. Live your best life with America's best value meal kit and get your first box for only $1.99 a meal. Plus, 20% off another 2 boxes using offer code EPTV199.
Behold, the hypnotic waltz of jowl, tooth, and slobber. Such a dance deserves a worthy partner. Super Chewer. Serious toys for ridiculous dogs.
It's okay to be curious. Curious about that unknown number. Who was that calling? Who keeps texting? What if it's actually important or an old friend trying to get in touch? For the next unknown number, use Been Verified. Be curious.
With medication, coaching, and lifestyle tweaks, Calibrate is changing the way the world treats weight.
You would think a pan is a pan until Made In came along, and I went, wow, these things are something better.
Those are the pans that we use at Alinea, at one of the best restaurants in the world.
It's built for a home cook like me, but fit for Alinea like him.
They are some of the hottest videos on social media. Those videos claiming to instantly get rid of bags under your eyes. Annette Figueroa is here to tell us why she says this one is for real.
This one is for real, and I'm so excited. Not only does it work on the bags, it works on the appearance of crow's feet, fine lines, and wrinkles. We even have a video, and all he uses is a small amount, and that's how easy it is. And I did this to my father. We were at home, 4 minutes, 34 seconds, completely gone.
My real true opinion is holy words I can't say on camera. This is absolutely unbelievable. I mean, I could feel it just lifting my skin. It was amazing. It feels good. Feels great. Looks even better.
At our $14.95 price, it's the best way to try Plexiderm and see it work for yourself after your first application. Your solution is at plexidermtrial.com or call the number on your screen.
There is no way to ignore it. You hear it on the news, online, from your friends and family. What happened to my money? Whether it got hit by falling stocks and bonds, with the coronavirus, shrunk by a floundering 401k with low interest rates, and is riding the extreme ups and downs of the stock market with political elections. Many Americans are worried about their money and how they're going to retire. Help protect your financial future now and call J.D. Mellberg for your complimentary book from a leading financial firm that shows you ways not to run out of money whether the market goes up or down. This free book reveals little-known truths about annuity strategies in simple-to-understand terms that can protect your money for a lifetime. As a bonus, we'll also throw in a free annuity rate report summarizing the rates and benefits of annuities from hundreds of top-rated insurers, helping you to find ways to get up to 33% more income in retirement. That's right. 2 books, both absolutely free, for calling J.D. Mellberg. Help protect your financial future.
Call 800-722-9185. That's 800-722-9185. Call now.
I've been having stomach troubles. It's either yogurt, pork, or citrus. Or almonds. Or maybe it's cinnamon. Now, I could start by removing a lot of things from my diet and adding them back in one at a time until I find the culprit. Or I could find out what might actually be bothering me before removing and adding foods back in again. I'm gonna do that.
All right, let's do a little update and recap on Colleen Maxwell. She turned 60 on Christmas Day while she was in jail. There were 5 days of full jury deliberation on this case. Prosecutors were probably a little nervous biting their nails on that one, but they came back with 5 of the 6 counts of the guilty verdict and on the serious charges as well. She is facing a massive sentence with respect to that, one that will likely keep her in jail for the rest of her life. We have an opportunity to speak to Sierra Gillespie. For Law and Crime is a reporter who interviewed Adam Classfeld. You may remember Adam was at the courthouse. Of course, it is federal court, so there are no pictures or video, unfortunately, for us to be able to review the trial. But Adam was our eyes and ears on the ground. Let's listen to Sierra as she interviews Adam about that one count that she was found not guilty on.
There were 6 counts. The one count of acquittal was enticement of a minor, and it related to the story of Jane. Now, here's the interesting thing. There were 2 counts that related to the testimony of the victim who was testifying under the pseudonym Jane. Maxwell was convicted on one and acquitted on the other. So insofar as did the jury believe Jane? The answer is clearly, at least in part, yes, they did, because she was the sole basis that they could have convicted Maxwell on these 2 counts. We know that this was a jury that was very methodical about their approach to the jury instruction, a 80-page document. They were looking not only at the facts, but the arguments about the law. They asked for the definition of enticement, which was behind multiple counts. They asked for what certain jurisdictional issues would be. So we don't know. Only the jury, should they choose to come forward at some point, can conclusively say what happened. But it's quite possible that they found that prosecutors had not met the burden of proof on the law. They could have had a different view of what the legal bar to convict on that count was. But it seems clear, based on the verdict, that essentially, to simplify it, they believed the women testifying before them. They believed Jane. They believed Carolyn, who was the sole person behind the 6th count of sex trafficking a minor. And then there was the testimony of 2 other women, one testifying under the pseudonym Kate, and the only victim who was testifying under her real name, Annie Farmer. They were behind multiple other counts that were found guilty. So this was, whatever the dispute was on that count 2, it is clear from the verdict that this was a jury that believed the women who testified in front of them.
You know, Karen, when these deliberations are going on, everyone's always calling and asking, can you give us an opinion about what's happening or not happening? And, you know, they don't know, like us, when we're trying cases, we're sitting in that courtroom trying to figure it out too. And we know it's a fool's errand. You know, it could be that there's a holdout juror. Why is it taking so long? It could be that they've agreed on 3 charges, but not 5 charges or 6 charges is in this case. But I have to be honest, if, you know, when I was a prosecutor trying a case, this jury had actually asked for readback of all of the 2 victims and the 2 404 witnesses, the 2 other women, to be read back to them. And then they started asking questions about the law, and it was going on for days. That would be unsettling to me as a prosecutor because, oh my gosh, they're asking about facts, and now they're asking about law. But in the end, prosecutors clearly won this case. Tell us a little bit about what goes through your mind when these questions come out and you're trying to figure out what it means, or it's not. They say don't do it, but it's impossible not to do unless you have some sort of Svengali ability to do it, Karen, that the rest of us don't. Talk to us about this.
I agree. It's tricky dealing with 12 people who don't know each other and are now put in this situation where they've all sat through days and days of testimony, listening to jury instructions, and some people probably fixate on particular things and come up with a verdict based on one particular thing. And then you have 11 people or a significant number of others coming up with different ideas as to what they believe and what they heard. So they can have readback, they can do all kinds of things, and some people just get fixated. I've never been on a jury. I would have loved to have that experience. Hopefully I will. But I think that when we have jurors asking for feedback, readback, and then they're like, this is my sticking point. If I get this clarified, then I will be willing to go along with the majority. So I think that when we do hear that juries have questions, it's not necessarily all 12 jurors having some questions. It might be one or two. And so once they get that clarified, they've gotten their sticking point unstuck and they can move forward with the verdict. So that is my sense, is that it's not all 12 people. It might be 1, 2, or 3 people, and they fixate on different aspects. And once they get that question answered, then they're willing to go along with the group to come back with a unanimous verdict.
Yeah, and it's really great to have Adam Klasfeld, our managing editor there, giving us like really sobering and really poignant observations based on his experience. So we're very, very accurate. Let's listen to a little bit more of his post-op, if you will, of the verdict.
Immediately after the verdict, we were waiting outside the courtroom because typically defense attorneys, after a verdict, particularly in a high-profile case, want to get their statement out to the press. And it's not uncommon that they announce an appeal. What Maxwell's attorney, Bobby Sternheim, announced is not only do they plan to appeal, they said the appeal has been in the works from the period between the counts of conviction to her actually exiting the front door of the courthouse. So she didn't let on what grounds she's going to be appealing on. It is unclear whether she will mention that because of COVID-19, jurors potentially could have deliberated over the holiday. Experts who I have spoken to do not think that that would be a winning argument if they were to go there. Essentially, that this is a very difficult time, the time of COVID-19. If the Omicron variant, which, as Judge Nathan said, had an astronomical spike in New York, if that spread to the jury and they got infected, we could have been dealing with a mistrial here. So she was walking a fine line. When the jury said that they wanted to adjourn early, she never denied that request. She gave the jury an opportunity to describe any hardship. If they had unmovable plans during the holidays, they could have informed the court, which it would have tried to accommodate. None of that happened. So insofar as we know they're planning an appeal, we don't know what that appeal will be, but the course of deliberations doesn't seem like it would be a very strong argument should they choose to make that.
Bob, let's talk about a little bit of those appellate issues. I mean, there was an issue one that they said that 2 of the 4 women that testified were not actually victims because it was not a state crime, which is required under the laws that they were charged with. The judge gave a curative instruction to the jury indicating that, or a limiting instruction and a curative instruction indicating that they can't be seen as victims, but they were admitted as 404 witnesses. That is to show custom, practice, bias, a lot of other things, not character propensity evidence. We don't see that often. We don't see the jurors being given limiting and curative instructions, but this court did. Do you see any basis for appeal, given that the general rule is the jury is presumed to follow the judge's instructions?
Well, as you and I know, appeal is a whole different animal. And it does start when the case begins, because an awful lot happens before the trial happens. And there are a lot of issues with respect to whether evidence comes in, how it comes in, and whether or not, and even with the jury charges. So a lot of that is all happening beforehand. Those rulings are all going to be subject to review on appeal. And then, of course, whatever happens at trial. The overriding issue here is that the defendant's entitled to a fair trial, not a perfect trial. So evidence that comes in and may not support an element of an offense, but is permissible in another context to establish another fact necessary for elements of other offenses. And there are limiting instructions in the evidence rules where the court explains that to the jury, that that's how they're supposed to use or view that evidence. And so, time and time again, that does happen in trials, whether or not that explanation to the jury was sufficient and whether this information was so capable of skewing the result because it had an impact on some other issues that may have been confusing to the jury, that is an issue that the appellate courts are going to have to look at.
Yeah, very, very well said with regard to the difference. It's not a second trial. It's based upon the legal issues and the rulings, and ultimately whether or not a fair trial is given. And it doesn't have to be a perfect trial. Well said, Bob Hille. Appreciate it. We're going to take a quick break here on the Law and Crime Network. We'll be back with more. Please stay with us.
I'm Jesse Weber, and you're watching Law and Crime.
Have you ever wanted to learn a new language like French, Spanish, or Russian, but thought it would be too difficult and time-consuming? Then go to Babbel.com and try it for free. Babbel works because it's built around real life. It teaches you everyday practical conversations that you will actually use. In 15 minutes a day, you'll be on your way to speaking a new language in just a few weeks. Babbel uses a modern conversation-based technique that makes language engaging, fun, and memorable. It starts by teaching you words and phrases. Then, sentences gradually get more complex. Soon, you're practicing short conversations about real-life topics. Babbel is created by language experts who use the spaced repetition method to help you learn quickly and remember what you learned. With Babbel, you can speak a new language because language isn't just about learning new words. It's about learning a culture, a mindset, and a new point of view. Babbel, language for life. Go to Babbel.com and try it for free today.
With Bonfire, you can easily fundraise by selling custom shirts online, upload your artwork, or create a design right on our website. In these unique times, you can still make a difference. Fundraise with custom shirts today on bonfire.com.
I sold my diamond ring with Worthy.com.
Their team of experts helped me understand its value.
Then they held an auction for their exclusive network of buyers.
So I got way more than the jeweler offered.
Sell your diamond jewelry for more with Worthy.com.
Are you waking up in the morning with a sore jaw, headaches, maybe even ringing in your ears, all because you're grinding and clenching your teeth at night? That's exactly what was going on with me. I end up going to a dentist and he wants to charge over $600 for a night guard. That's when I found this, the Brooks Night Guard. This was a game changer. It's smaller than other night guards that I tried, which is a good thing because it doesn't make me gag. It could fit on the top or the bottom of the teeth. It's lightweight and super comfortable. Other mouth guards go all the way to the back. This allows the back teeth to continue to touch. Now this is where most of the grinding and clenching occurs. Now the Brooks Night Guard redirects the bite force away from the back teeth, reducing jaw pain while still protecting the teeth. This unique design is what makes Brooks Night Guard different from all other traditional grind guards. Go to brooksnightguard.com and order yours today. Your teeth will thank you for it in the morning.
Go to brooksnightguard.com and use promo code BROOKS33.
At Finger Hut, we don't define you by your credit score. We celebrate you being you. So we offer low monthly payments on the stuff you need, things you love, and brands you trust. As you build your credit history with a Finger Hut credit account. If you're looking for the latest electronics, kitchen essentials, clothes, toys, and more, you'll find it all at Finger Hut. You do you, and we'll help build your credit at fingerhut.com.
Finger Hut credit accounts are issued by WebBank, member FDIC.
Okay, as we indicated to you before, Dayonte Resiles is a retrial. And going back, this victim is 59 years of age, and there were 5 days of deliberation on a previous trial. And the jury came back with a manslaughter verdict. But while the judge was polling the jurors, one of the jurors said, I can't go along with this, and told the court that they had agreed to the manslaughter only because 3 jurors refused to convict a black man and send him to jail for the rest of his life. Caused the jury to go back into the jury room. Ultimately, a mistrial was declared. The defense has tried to raise the issue that double jeopardy applies. The judge had none of that. And of course, reasonably speaking, the verdict was not finalized, so there is no double jeopardy issue there. The victim in this case was found in her home with her hands and feet bound, and she was stabbed multiple times. The prosecution alleges that the defendant went into the home to commit a burglary, thought the home was empty. When the home wasn't empty, he commits this murder. Bob Hille, I mean, I've only seen one other instance in my career in which during the polling of a jury, the juror says they can't go along with the verdict and it causes them to go back into the jury room. Have you ever witnessed this before? It is extremely unusual and rare based on my experience. Your thoughts?
I mean, I've personally never experienced it with any of the juries that, I've obtained a verdict from, civil or criminal, but I'm sure it happens. I've heard many stories like your experience. So it does happen. We all have a feeling, or at least from some of the jury surveys and studies, that they tend to compromise verdicts frequently, certainly in the civil context, but sometimes in the criminal context. So in this case, I think the jurors did do the right thing and say, look, it wasn't our verdict, because that needs to represent what that jury did. And if the jury didn't really do that, then that person was right in saying that.
Karen, this is one of the reasons I think we're always afraid to go to trial. And I'm seeing more and more of it lately. I mean, how many times can a court instruct to follow the facts and the law, not to be persuaded by passion, bias, or prejudice? There's no business about race being discussed in the jury room. And the judge specifically tells the jurors in most jurisdictions, I'm sure it's here, that it is not your role to be concerned about sentencing. That's the court's role. What are your thoughts about all of this?
I believe that the jury gets overwhelmed and that there's a lot of information that's being thrown at them. We have to go by the counts, how many counts there are that the person's being charged with step by step. Has the prosecution proved each count beyond a reasonable doubt? So they have to deal with that information. They have to deal with the fact that they're now in a group of people that they've never been with, and they have to come to a consensus. And so I think that it's so imperative that we do poll juries. A lot of times, depending on the case, I've seen as a criminal defense attorney here in the Bay Area that the jury isn't polled. And so the verdict is read, and then we go on to sentencing if the person's convicted. And so it's so important. And in this case, it shows critically why it's important. I've never, like Bob, I've never had that situation where the jury's been polled and it comes out this way. So I think it's critical in that as a defense and a prosecutor, we need to be aware that people do need to be polled, because there's some miscommunication or going to sentencing, actually rushing to the judgment of sentencing before focusing on the guilt and innocence and seeing sentencing as a separate and apart from that. And that's what happened in this case.
Yeah, really interesting. And it's surprising, Bob, that it happened in a case of such vociferousness in terms of the murder, hands tied, feet bound, stabbed multiple times. It wouldn't be the kind of case you would imagine people would have any kind of sympathy for. But let's switch gears, Bob. This Rogel Aguilera-Mederos, this was the truck driver who went to trial on a vehicular manslaughter charge, 4 victims in the case, indicating that basically that an accident occurred. I was trying to get out of the way and I couldn't, and caused a chain reaction. The prosecutors arguing that there were off ramps that he could have taken that he did not avail himself of, and therefore his conduct was reckless. The jury came back with a guilty verdict. Bob, the judge sentenced him to 110 years in state prison. And I heard this and I was in disbelief. I had to read it over again. And I understand, and I've prosecuted these cases. These are the most difficult cases to prosecute. First of all, he's not under the influence. He's not really doing anything nefarious. Split-second decisions are being made. Can you make any sense of how this sentence came down? And moreover, now it's been reduced to 10 years. This is what happens when the public gets involved in it, but it shouldn't be this way. You shouldn't need the media and millions of petitioners to get your sentence reduced, Bob.
Well, and this has always been the debate between discretion from a judge and mandatory minimums. Mandatory minimums started to creep into the law because, there was concern that the judges were exercising their discretion in inconsistent ways against members of various communities. So a way to avoid that was create these mandatory minimums. Now, this is a mandatory minimum gone amok. I mean, 110 years. This was a terrible, terrible event that happened. Yes, 4 victims, died in this. But again, 110 years, as you pointed out earlier, I think in the show, that you don't have murder. Defendants convicted of murder that get put away for there. So at what point does a mandatory minimum really violate the 8th Amendment, which says no cruel and unusual punishment? And a case could be made here that when you apply this law, if it's applied even correctly, we don't know that for sure, but the judge found a way to get around that, I guess. But assuming it was applied correctly, then you got to look at, is it constitutionally sound? And it doesn't look that way here.
This is what gets me nervous, Karen, is that prosecutors' responsibility is not to seek convictions. It's to achieve justice. And the bottom line here is that the prosecutor went along with this, and so did the judge. To Bob's point, there is a carve-out. There is an ability to argue exceptional circumstances. That's how we got to the reduction of the sentence to begin with. But how many people are going away with ludicrous sentences like this that don't have the support that this gentleman did, that are spending the rest of their life in jail for, really, if you ask me, amounted to an accident? In many jurisdictions wouldn't have even prosecuted this case.
Thousands upon thousands. And it's really sad because we have a situation where the truck driver is a agent of the company. That was out of state. It was in Houston. We're in Colorado where the accident happened. So there's, to my knowledge, been no charge against the company because the evidence showed that there was some brake failure. And he was, I believe, 23 years old at the time. He didn't have the experience to drive this type of rig in those conditions in Colorado.
Right.
And when we have this punitive sentences, it's for deterrence, right? There's no way that this was something that could be deterred. It wasn't an intentional act at all. It was. Yeah. So that's my read on it.
Karen.
It's really unfortunate.
Karen, I think you make an excellent point about deterrence, and that's what the prosecutor's supposed to be doing. And this sentence certainly wasn't achieving that. Okay, guys, great commentary. We're going to be back with more on the other end. Please stay with us.
I'm Dr. Lakeisha Simmons. 4 years ago, I was a single mom and I was living paycheck to paycheck. That's when I downloaded the free Personal Capital app, and it changed my financial future. I linked all of my accounts and I instantly saw where I stood. I was able to track my budgets and spending and see how that affected my net worth. Now I use the retirement planner and I monitor my entire portfolio. 4 years later, my nest egg has grown and I'm ready to retire.
Download the free app or go to personalcapital.com today.
Holiday party season is finally here. Now, what to wear? JustFab's VIP membership makes it easier than ever to turn heads at every party. With a huge selection of festive boots, booties, heels, and more, with on-trend details that always feel elevated and chic. And of course, every pair is so comfortable. The best part, you get 2 pairs of great shoes from just $29.95 when you join today. Own your holiday parties this year. Sign up now at justfab.com.
A band of brothers, finally reunited after 30 long years. Use Been Verified to search for the people you miss. You might just find what you've been missing all along. Been Verified, know better.
It wasn't Meta's fault that yo-yo dieting failed her. Calibrate works with her biology to end an unsustainable cycle. Medication, coaching, lifestyle tweaks. Lose at least 10% of your body weight or your money back. Join Calibrate.com.
Say yes to a world of possibilities with Zola and plan your whole wedding in one place. Start with venues and vendors near you that fit your style and budget. Then explore save the dates and invites. Get free samples to see them in real life. Keep guests updated on a free matching website. And even stream virtual events on it for free. Then build your registry. Add gifts to make married life even sweeter. Get started for free at Zola.com.
This right here is confidence in a bottle. It just gives you such a boost to confidence.
Not only does it change you on the outside, but something in the inside, knowing that you're looking better.
It makes me feel so much more confident than I've ever felt in my life.
They are some of the hottest videos on social media. Those videos claiming to instantly get rid of bags under your eyes. Well, today we're going to see one for ourselves and let you be the judge. It's called Plexiderm, and lifestyle expert Annette Figueroa is here to tell us why she says this one is for real.
This one is for real, and I'm so excited. We even have a video, and you'll notice the model has bags underneath his eyes and some sagging, and all he uses is a small amount on a clean, dry face, and that's how easy it is.
All right, what's the active ingredient?
Okay, so it's silicates that are minerals found in shale rock, and what it does is it tightens and lifts the appearance of bags underneath your eyes, and as little as 10 minutes, no prescriptions, and very little effort. Even watching the video, this is a real, it's a model, but it's a real guy with real bags underneath his eyes. And I did this to my father. We were at home. I had the timer on, and we were screaming. 4 minutes, 34 seconds, completely gone.
My real true opinion is holy words I can't say on camera. These lines bother me. They really do. And this is absolutely unbelievable. I mean, I could feel it just lifting my skin. It was amazing. It feels good. Feels great. Looks even better.
And not only does it work on the bags, it works on the appearance of crow's feet, fine lines, and wrinkles. So it targets all those problem areas.
So this would be a daily thing, or
it absolutely could be a daily thing. But the way you want to do it is you want to have a clean, dry face. You use a small amount because it's so powerful. You have high school reunions, you have events you want to go to, you want to look years younger. This is it.
At our $14.95 price, it's the best way to try Plexiderm and see it work for yourself after your first application. Your solution is at plexidermtrial.com or call the number on your screen.
I'm Brian Buckmeyer, and you're watching Law and Crime.
Welcome back to Law and Crimes for the Record. My name is Bob Bianchi. I'll be taking it to 3 o'clock. Chandler Henderson is another case that we are in the middle of. We're going to be covering this gavel to gavel. Jury selection is underway. He is being accused of killing and dismembering his parents, in addition to multiple other charges, including intentional homicide, kidnapping, falsely reporting a missing persons case, mutilating a corpse, and hiding a corpse. It's a really gruesome and horrific case. The evidence in the case is very interesting. Again, jury selection is underway right now. Let's listen to a little bit from earlier today when a judge was speaking and addressing to the jurors. Obviously, the most difficult part of the case is to get them to come on board because many of them know about the case. They want to make sure you can get that fair and impartial juror. So let's listen, jury. So let's listen to the judge as he's speaking and addressing one of the jurors.
So first, let me read to you the amended information that has been filed and that will be tried. And again, as I said, this is just for informational purposes only. This is not evidence, and this is nothing from which anyone should draw any conclusion whatsoever. Count 1, and with all these counts, they reference the above-named defendant, that is Mr. Halderson, for each and every count. Count 1, first-degree intentional homicide. The above-named defendant on and or between July 1, 2021 and July 8, 2021, Dane County, Wisconsin, did cause the death of Bart A. Halderson with intent to kill that person, contrary to section 940.01 sub 1 sub A. Count 2, false information on kidnapped or missing persons. The above-named defendant on and or between July 1, 2021 and July 8, 2021, Dane County, Wisconsin, the defendant did deliver written and or oral communication with intent to induce a false belief that the defendant had knowledge of the whereabouts or physical condition of a missing person, Bart A. Halderson, contrary to section 946.48 sub 1. Count 3, mutilating a corpse. The above-named defendant on and or between July 1, 2021 and July 8, 2021, Dane County, Wisconsin, did dismember the corpse of Bart A. Halderson with the intent to conceal a crime, contrary to section 940.11, sub 1. Count 4, hiding a corpse. The above-named defendant on and or between July 1, 2021 and July 8, 2021, Dane County, Wisconsin, did hide the corpse of Bart A. Halderson with the intent to conceal a crime, contrary to section 940.11 sub 2. Count 5, first-degree intentional homicide. The above-named defendant on and or between July 1, 2021 and July 8, 2021, Dane County, Wisconsin, did cause the death of Krista R. Halderson with intent to kill that person, contrary to section 940.01, sub 1, sub small letter A. Count 6, false information on kidnapped or missing persons. The above-named defendant on and or between July 1, 2021 and July 8, 2021, Dane County, Wisconsin, the defendant did deliver written and or oral communication with intent to induce a false belief that the defendant had knowledge of the whereabouts or physical condition of a missing person, Krista R. Halderson, contrary to section 946.48 sub 1. Count 7, mutilating a corpse. The above-named defendant on and or between July 1, 2021 and July 8, 2021, Dane County, Wisconsin, did dismember the corpse of Krista R. Halderson with the intent to conceal a crime, contrary to section 940.11, sub 1. And finally, count 8, hiding a corpse. the above-named defendant on and or between July 1, 2021 and July 8, 2021, Dane County, Wisconsin, did hide the corpse of Krista R. Halderson with the intent to conceal a crime contrary to section 940.11 sub 2.
All right, there you go. There are the charges being read to the jury. We have Karen Felecia Nance, that is with us right now, criminal defense attorney, and the great Bob Hille, hailing from the state of New Jersey, a trial attorney and former president of New Jersey State Bar Association. So guys, Karen, let me start with you. Kind of gruesome, case here. What are your thoughts so far about the strengths of the prosecution's case?
The prosecution appears to have a very good case. We don't have the exact date of death because the parents went missing July 1st and their bodies were discovered, parts of their body, unfortunately, on July the 8th. And so that's why the instructions, the counts indicate that it's between these two dates that these people were killed. So I think that it just reading it and hearing it, it sounds. You look at the defendant, the son, and you're wondering what is going on here, what happened here, especially since he doesn't have any record. So I'm hoping that in the presentation of the case, we hear from the witnesses. My understanding is there are going to be many witnesses called by the prosecution. So just the reading and the dismemberment language is just off-putting, and unfortunately, I believe the potential jurors are going to think that this person has a lot to do with it. Who would dismember bodies? Somebody that's very close to these people. And so it just conjures up all the things we see on TV.
Yeah, Bob Hille, let me ask you, Sarah Gillespie, a reporter from the Law and Crime Network, indicates that during jury selection, 3 jurors have been dismissed because of their familiarity with the case and because they've already formed an opinion. Talk to us about how difficult it is for judges to ask jurors questions. Many times the judges will ask, am I not right, Bob? Or can you set that opinion aside and based on the evidence you hear in this courtroom? But judges have different temperaments as to whether or not they're going to have a for-cause challenge or not. Some will let them on even if they formed opinions, and some won't let them on if they formed any kind of opinion. What do you think?
Well, I think there's less of a danger of that in the criminal context than there is in the civil context. Where there's that sort of incentive to try and get the case moving and get it done. Not to say it doesn't happen in the criminal context, but in the criminal context, the court needs to have at the forefront the constitutional guarantee for an impartial jury. And this idea of fairness or what process should be due here to this defendant comes in under the Fifth Amendment. So, those are the guideposts here that the court has to always be mindful of. And that's always the difficulty here. You have to give the jury information about the case. It's likely they've heard it in the press, social media today. A lot of this stuff gets out, but you need to give them enough information so that they know whether or not there's something that's going to interfere in the examination process by the court and the counsel with their impartiality or fairness. So they got to get a clue. But by the same token, you don't want to do it in a way that could prejudice the defendant in the eyes of the panel before the trial even starts. And that's always the balancing act that every court and counsel are faced with in every one of these cases.
All right, let's switch gears a little bit, guys. Dayonte Resiles is a defendant who is on trial for the second time. Karen, in his first trial, there was a murder case. The jury came back with a manslaughter conviction, but while polling the jurors before that verdict was finally accepted by the court, one of the jurors stood up and said, nope, I can't go along with this. 3 jurors refused to convict for murder and only would convict for manslaughter because they wouldn't convict because he was a black man and didn't want to send him to jail for the rest of his life. The judge then ultimately declared a mistrial in the case. The case is being retried. Defense attorney is trying to argue that double jeopardy was implicated there. Of course, that was an argument you make, but it's not one that legally was going to, withstand that kind of scrutiny. This is about a 2014 murder of a woman during a burglary attempt. The prosecution argues where she was found face down in a tub, bound by her hands and her arm, or rather her hands and her feet, and she was stabbed multiple times. So talk to me, is it not odd to you that, we know about jury nullification. We talk about that a lot on our show. And it's a real concept where jurors can either find you not guilty or to lesser charges because they feel sympathy for you. But this isn't the sympathetic kind of defendant. Did it surprise you that that was going on in the jury room, that 3 people refused to convict on a case of this magnitude?
Definitely. And it makes me wonder what the voir dire was like. What was the questioning of the potential jurors? You would think that both the prosecution and the defense would have hammered that fact home, that we need to listen to all the evidence, but the evidence is not the conviction. We can't focus on if the person is found guilty, what the sentencing will be. So I don't know if there was a misstep at that point, or maybe this is a lesson to all of us, both prosecution and defense attorneys, that fact needs to be focused upon. Don't only focus on the evidence as it's presented. And once there is a finding of guilt, if that's the finding, then you go to sentencing. And so for some reason, at least 3 of the jurors didn't get that message during the voir dire, and they were fixated on the sentencing maybe throughout the whole trial, which is a huge problem.
Yeah, it's one of the reasons why, even though I've tried death penalty cases as a prosecutor, I've since changed my opinion because of things like this that are so askew in the criminal justice system, and the ultimate penalty is not reversible when you find out about them later on down the road. It is a flawed system for sure. Bob Hille, speaking of part of a flawed system here, is, and I'm going to read this because it's a little odd to me, I want to make sure I get it right. States informed the court they may need approval to use Google Maps image since getting the actual photographs of the scene proximity is delayed. The hair retesting is also backed up. Handwriting analysis has also not been completed due to delays. And this case is supposed to start tomorrow. The defense says they have a right to and need the time to see the new evidence or whether new experts should be brought in. Bob, I just would be apoplectic first of all, I'd be very disappointed as a prosecutor. I'm surprised the judge isn't down the prosecutor's throat. How can you be in this position? And doesn't the defense have a right to be able to have time to confront this information?
Well, I think yes and yes. I think obviously there are a lot of factors going on with COVID and everything, trying to get cases together, getting people, staffing, appropriate laboratories. So there may be a justifiable delay here as to why the state doesn't have certain things ready. But obviously, at the end of the day, as we talked about before, the court has to make sure there's a fair trial here so that the public has confidence in the result and how the system dealt with this defendant. So, the defense has to have an opportunity to be able to confront this evidence because the Constitution requires that. And so they're going to have to be given a full opportunity to do that.
Yeah, it's really amazing. And so, we'll see where that goes. Well, guys, listen, Crystal Daniels is back, obviously in the news. There's going to be a trial that's going to be occurring within the next month. And you may remember that's with regard to the disappearance of baby Joe. The father of the child had been convicted. We covered that gavel to gavel here at the Law and Crime Network, serving a 51-year sentence. She's being charged with various charges, including aggravated child abuse. So that'll be an interesting case to watch. A little bit more circumstantial, maybe a little bit more difficult for the prosecution with respect to her. Maybe not. We'll see as the evidence comes up, but you can be assured that we'll be covering it here at the Law and Crime Network. Let me take a quick break. We'll be right back.
BarkBox isn't just a monthly delivery of dog goodies, it's a passport to a whole new world with toys and treats from a different theme every single month. To start your dog's adventure, go to BarkBox.com.
My leg hair was coarse enough to braid, and this razor sailed right through it. I'm like a naked dolphin. Yes, I know. Dolphins are already naked.
No one can deliver your mom's homemade short ribs. That's why Instacart helps deliver the ingredients, and you add the love. Visit instacart.com or download the app to get free delivery on your first order.
You would think a pan is a pan until Made In came along, and I went, wow, these things are something better.
Those are the pans that we use at Alinea, at one of the best restaurants in the world.
It's built for a home cook like me, but fit for Alinea like him.
From the makers of top-selling Super Beets comes new Super Beets Heart Chews, a superfood breakthrough that's bursting with flavor and unique polyphenols that help support healthy blood pressure and circulation so your body can produce more heart-healthy energy.
The chews are so great. Super Beets gets me going. It gets my circulation flowing, and I have that energy all through the day. It's just fantastic. I love it.
When I researched Super Beets, I was impressed by all the science behind the Super Beets chews. It's amazing that something so simple can be this great for my heart.
What makes Super Beets polyphenol so different from other antioxidants? In a leading clinical study, Super Beets polyphenol compound was shown nearly 2 times as effective at promoting normal blood pressure as a healthy lifestyle alone.
In my 31 years of helping people maintain healthy blood pressure, I've never seen a polyphenol compound this effective. Super Beets antioxidants help support healthy blood pressure and help your body produce more energy.
I never knew how my blood pressure and my blood flow were so connected to my energy level, and now I know. I'm playing tennis longer, I don't get tired after one set. I can totally feel the difference.
Call now and find out how you can get a free 30-day supply of Super Beets Heart Chews plus a free bonus pack of delicious vitamin D3 chews for immune health support. Act now and we'll even include free shipping and free returns, all backed by our 90-day money-back guarantee. That's over $30 in total free gifts. So try Super Beets Chews today.
I love the chews because they're delicious and they're so convenient.
I absolutely love what they do for my energy. My blood pressure is healthy and my energy level has been phenomenal.
So do something good for your blood pressure and your energy. Love your results or your money back.
Call 1-800-394-0557 or visit superbeetschews.com. That's 1-800-394-0557. Call today.
I'm Dan Abrams, and you're watching Law and Crime.
Welcome back for the record. We are talking Crystal Daniels. This trial, as I indicated prior to the break, is going to be commencing shortly. She's charged with aggravated child abuse. As you know, the father of the child had been convicted in gavel-to-gavel coverage that we did here at the Law and Crime Network, where he received a 51-year sentence. She's being charged with the aggravated child abuse charge. Question is, can the prosecutors do the same good job that they did in the first case with the father as they can with the mother? A pretrial hearing occurred on December 28th, and very interesting because they were reading transcripts from statements that Crystal Daniels gave during the conducting of a polygraph examination. Let's take a listen to some of this enlightening information that you can be assured will come out before the jury.
Okay. Line 24. What statement does the defendant make to you, Agent Lawyer?
Notes that she nods her head and then states, "I just don't want my father-in-law coming after me."
And then going to the next page, 140, starting with line 7, what statement does the defendant make?
Ms. Daniels states, JoJo punts Baby Joe ND, and Agent Boyd asked how JoJo punched Baby Joe in the face.
Thank you. And what does the defendant say on line 16?
Ms. Daniels states, I heard Baby Joe cry, and then it got quiet.
You asked a question beginning on line 6. What is your question to the defendant?
Okay, so you get up, and what do you see when you get up and go in the hallway? Where was JoJo standing?
And the defendant's answer?
She answers, he was in the living room.
And then your question to her?
And where was Baby Joe? And she replied, on the floor.
Okay. And then you ask another question on line 12. What's that question?
Okay, come on, Crystal, we need the truth. Just keep going. What did JoJo say? And she,
go ahead.
Yeah, I'm sorry. She answered, he told me if I said anything, he was going to kill me.
Okay. And did she make an additional statement on line 23?
She replied, I didn't because he swung at me.
Let me back you up to line 19. Agent Boyd asked a question of the defendant. Is that correct?
Yes, sir.
And what was that question?
Agent Boyd asked, did you rush to Baby Joe? Did you check on him to see if he was okay? I mean, if you didn't, tell me you didn't. It's okay. It's a scary situation.
And what was the defendant's answer?
She answered, I didn't because he's funny. Yes, sir.
Agent Boyd asked a question on line 2.
JoJo did he hit you?
And what was her answer?
She replied, no, he didn't hit me, but he came close to it.
All right. And skipping down to line 21 on page 144, what does Agent Boyd ask the defendant?
Okay, and how do you know JoJo punched him in the face?
And her answer?
She answered, you could see it.
And Agent Boyd?
You could see what? Ms. Daniels' answer was, well, for one, whenever a man, it goes over to page 45, a man has his hand balled up like that, and she demonstrated, shows demonstrated.
Okay. And on page 145, line 6, what question does Agent Boyd ask of the defendant?
What did Baby Joe's face look like? Could you tell he had been hit?
And her answer?
I couldn't even get that close to him.
All right, interesting information. Like I said, certainly going to come out before the jury, in my humble opinion. The agent was also cross-examined by the defense attorneys. Let's see, again, giving you an insight as to where they may go before the jury, how he, the defense attorney, cross-examined this witness.
Yes, sir. The test started at 1:18 p.m. or the interview, pre-test interview started at 1:18 and completed at 7:47 p.m.
Okay. And based on the document that was made an exhibit, she had a 4-minute break from 2:03 to 2:07 p.m.
He was offered multiple breaks.
All right, that's good to know. How many did she have?
There were times that she just sat there and times that we left the room. But
Agent Faulkner, what's the problem? She had one 4-minute break. Will you just not agree to that?
Sir, I mentioned earlier there were other times that she was offered breaks. And
I'm not asking whether she's offered a break.
That's what that, yes, sir, that's what that indicates.
Okay. After she was advised of the results of the polygraph, was she re-Mirandized?
No, sir, there was no need. It was a continuous.
Okay. I didn't ask for an explanation. Was she re-Mirandized after you told her she failed the polygraph? Thank you.
Karen, I find this to be really interesting. I will give you an insight. When I used to teach prosecutors in trying homicide cases, actually, Bob Hille is in my jurisdiction. I never had the honor of trying a case with Bob, but my training would be that be careful of what statements you're admitting of the defendant, because a lot of times the statements may sound like a confession, but they actually put into the trial the defense that is being raised. And if you put in the defense through the statement, follow my logic here, the defendant doesn't have to take the stand. Whereas if you don't admit that statement, if you could still prove your case, and I've done this in murder cases, and the defense is like, what do you mean you're not going to use the statement? I'm not going to use the statement. I think I can prove it outside the statement, because I knew the statement had information. It was like either passion provocation or manslaughter, and that forces the defendant to the witness stand. Is it possible, if the prosecution introduces this statement based on what we heard, we may hear that there's not the correct mens rea, that is, whether she acted with knowledge or purpose as opposed to an incident that happened unbeknownst to her, that she was not a participant in, and moreover, her fear of him in a domestic violence capacity? Thoughts?
Absolutely. I believe that this is very strategic on the part of the defense and can be very effective. With regard to the domestic violence, Bob, that's the first thing that came to my mind. It's very scary, just the recitation of the events of him having his fist balled up and the fact that she couldn't even get close, or felt like she couldn't get close to her son on the floor to see the amount of damage that was done, the injuries that were inflicted on him. And this is not the first time, I'm assuming. We can assume that with domestic violence cases, there's always a buildup. There's something that's occurred beforehand. And so there's a certain amount of empathy, if not sympathy, for the mother of this case. And then we're talking about a child that has autism. And being someone who's an advocate for families with children and adults with developmental disabilities, the stress on family members trying to assist is very huge. And so I think that I'm hopeful that the defense will bring that out in the mother's behalf, because she's not only dealing with a potentially violent husband in the household, we're dealing with a child who can't adequately regulate their behavior. So that's hugely important. And getting that information out through this witness is very, I think, beneficial for the defense in the long run.
You know, Bob, Karen brings up great points as always, but you know, there's always this double-edged sword with facts. That very well could be that she was the victim of domestic violence and abuse, whatever. But to Karen's point, this is also a child with a disability, which requires that the mother, the defendant here, Crystal Daniels, even have more of a responsibility to ensure that child was protected. Could the argument by the defense making that she was kind of under an abusive situation, if that's where they go, actually inure to her detriment, because she should have gotten out of that earlier, especially with a developmentally disabled child?
Well, I think so. I mean, that's certainly got to be a concern for the defense. I mean, you know, this is a vulnerable child. It's your child. You know this child is vulnerable. This child is now in a situation where the child is being harmed in some way. Maybe you're not cognizant, or know that it's a very serious issue, and there's probably been a history of abuse and frustration and physical attacks by her spouse on this child. But we all, I think, in looking at this, would say, hey, a mother should be, like a bear and a bear cub. That mama bear should be running to save that cub no matter what. And her just sitting there quiet, even if she was in fear for her safety, and obviously that was legitimate given this nature of this person. Again, it could backfire and hurt. But again, at this stage, they're trying to keep this evidence out. So it's really an issue of whether or not this comes in. If it does come in, then these other issues are going to come into play.
Karen, real quick, you're an advocate for children and a vociferous protector of children. Are we being too Pollyannic? I mean, there are other issues that are at play with situations like this. It is a developmentally disabled child. Money is always an issue with regard to abuse and whether people can break that cycle of violence. There is the cycle of violence itself. Is this a trap where people can't get themselves out? And if so, do you expect the defense to argue that?
Absolutely. There's this assumption that the mother in this case, and with all deference to Bob, we want to believe that a parent is going to do the best for their child, but sometimes we just don't know how to do that, especially when you're talking about something as diverse in terms of the implications of autism. We have a spectrum. It's called an autism spectrum. So the behaviors change from day to day. The behavior of a child can be high one day, low the other day. They're not going to respond in terms of discipline the way a neurotypical child does. And so I think it's very imperative in this particular case that the defense would bring this out. And they have to, it's a strategy, right? Are they going to have the mother testify? If not, then they're going to have to try to bring out this information in another way through other, maybe their family members that can talk about how this child behaved and whether she even had assistance in dealing with the struggles of being a parent of an autistic child. So I don't know if he was in school. There are a lot of issues.
Yeah. Okay, well said. And then you certainly have that background and experience to help educate us. All right, guys, we're going to take a quick break here in the Long Crime Network. When we come back on the other end, hopefully somewhere down the line, we'll have Adam Classfeld with us on the Maxwell verdict and the fallout from that. Please stay with us.
I'm Terry Austin, and you're watching Law & Crime.
You can either spin the wheel and win a delicious meal with an affordable price tag, or you can pay $100 for this drawing of dinner.
I'm gonna need a second to think about it.
Okay, well, while he's figuring that out, Emily, what's it gonna be?
The wheel.
Emily, you've won a delicious, simple, and satisfying dinner with every plate. Get your first box for $179 a meal using offer code TD179.
Without personal capital, there's absolutely no way we would have had the financial confidence to live the life that we're living. Both the tools and our personal capital advisor give us the comfort to not have anxiety about our retirement.
I never imagined this dream would come true. Working with our advisor at Personal Capital, we were able to make that leap.
Take control of your retirement. Download our free tools, then talk to an advisor. Start today at personalcapital.com.
First dates and the joy of finding out they're exactly who you hoped for. You've been verified to search the people you've matched with. You could find the info you need to let love do its thing. Been verified. No better.
With science-backed Calibrate, Vicky's weight loss is sustainable, ending years of unsustainable yo-yo diets. Medication, coaching, lifestyle tweaks. Lose at least 10% of your body weight or your money back. Join Calibrate.com.
Finding the perfect bra can be impossible. Pinching and tight here, sagging and loose there. It's so uncomfortable to wear. And back fat from your straps? Who needs that? Hi, I'm Taylor Baldwin, and you're gonna love this. It's the Comfy Corset Bra. Comfy as a cami, but sexy as a corset. Finally, a bra that does it all. The secret is the revolutionary front crossband design. Just pull across to adjust the bands over and under. Comfy Corset complements your curves under any outfit, lifts in all the right places, supports you all day long, and with no underwire, tags, or seams, it feels like you're wearing nothing at all. It's the perfect combination of a figure-flattering push-up bra and a super comfortable bralette. You can customize the fit to your breast shape and size, even if that's different from right to left. Just look at the difference. And ladies, you can say goodbye to embarrassing back fat because Comfy Corset beautifully takes care of that. You can even customize Comfy Corset to your outfit. Adjust here for a sporty fit under a t-shirt or blouse, or here for a sexy look in that little black dress. Comfy Corset Bra doesn't constrict or squeeze, but still enhances your cleavage. Beautiful lace trim adds that sexy secret. Comfy Corset Bra is made of premium, breathable, quick-dry fabric, so you won't have to worry about sweat. Plus, it's machine washable and dryer safe.
You can get 3 Comfy Corset bras in your choice of black, nude, or any combination for this special TV discount price of just $59.99. Call or go online now to find out how you can get a second set of 3 for 50% off and free shipping. But you have to order right now. If it's not the most comfortable bra you've ever worn, return it for a full refund of the purchase price. Call or go online to comfycorset.com now.
When Jamie and Logan joined First Leaf, they thought they were just going to discover new wines. And sure, they learned they love French Shiraz. What they didn't know was First Leaf tastes over 10,000 wines a year and only 2% make the cut. And the more wines they rate, the more personalized their selections become. That's why First Leaf gets better with every box. First Leaf, try your first 6 bottles for $39.95. Satisfaction guaranteed.
Welcome back to For the Record. Colleen Maxwell, well, that verdict is in. 5 of 6 counts guilty. She was only found not guilty on 1 count. She turned 60 on Christmas Day, and she certainly did not get a Christmas present with this jury's verdict. Multiple days of deliberation. The jury asking for readback on 2 of the victims and 2 of the 404B witnesses, the other women that supported the victim's testimony, as well as a number of questions with respect to the law. As you know, in federal court, we don't get the videotape or photograph, which is really unfortunate. But we have Adam Klasfeld with us. We don't have to be that unfortunate. He was our eyes and ears on the ground, boots on the ground. Adam, you did a great job covering this trial. And thank you so much for that, because I was reading all of your notes that you were sending in to give us an idea of what was happening so we could competently comment on this. Adam, talk to me first about this one enticing count that she was found not guilty on, and how much, to your knowledge, will that affect the sentencing here?
Well, thank you for having me. In terms of the one count of acquittal, that enticement count involving Jane, there are a couple of interesting things about that. One, there were two counts that involved the testimony of the first witness, the first accusing witness for the government, Jane. She was found, Ghislaine Maxwell was found guilty on one of her counts as well. So she is now officially one of Ghislaine Maxwell's victims. It was one of the smaller counts in terms of sentencing exposure, because Ghislaine Maxwell is now facing the possibility of several decades of imprisonment. Just to give you an idea, the one top count of sex trafficking a minor was 40 years imprisonment. That related to the testimony of another victim, Carolyn. This one count of acquittal spared her a maximum 5-year sentence. She is facing a possible sentencing exposure of 65 years. Now, again, I should emphasize this is at the top end. This is a maximum. Her sentencing guidelines should be lower, but according to the calculations of experts I've been speaking to, the sentence is likely to be something that would be akin to death by incarceration.
Yeah, Adam, I want to get into that because I think there's a lot lost here in the analysis of what I'm hearing on in other places, certainly not the Law Crime Network. But you have to understand the federal sentencing structure. There are those guidelines, but this case now goes to the probation department. And the probation department is going to prepare a pre-sentence report for the judge. And they're going to go through all the guidelines and all the sentencing calculations. But there's also things called like relevant conduct and cross-references, which could jack that number higher. I don't want to get into the dirty details of it all, but based on what you viewed on the case, let's use our common sense. You're dealing with a person that the judge listened to this testimony. He listened to a person who is for all intents and purposes, a serial abuser convicted of working in concert with Jeffrey Epstein to abuse not just these people. The judge can go even beyond all of that with regard to relevant conduct as to the scope and nature of this criminal enterprise. Doesn't seem to me to be the likely kind of defendant where the judge is going to go easy on them, given the constructive and nature of it, in addition to the fact that this was a woman who was using her womanhood, if you will, to kind of entice these younger, I'm using entice with a small e, not statute-wise, to feel comfortable to be put in this environment so that they could be abused. I just don't see a judge not throwing the book to the extent that that judge could with a case like this. What do you think?
Well, as I said earlier, even the sentencing guidelines, let's just say she doesn't give an above guideline sentence. The guidelines themselves, according to some of these calculations, and you're right, this is going to go to the probation department. They will have their say. But according to folks who are crunching these numbers, we're already talking decades. Ghislaine Maxwell she spent her 60th birthday in a federal jail. She turned 60 years old, and we're talking about a guidelines that could easily go to 20 years. And that, of course, the judge has her discretion. If for all the reasons that you said, she wanted to go higher than what would already be a very heavy sentence of 2 decades in prison. Or if even, let's just say that Ghislaine Maxwell wins on certain points of contention, we're still talking 12 or 13 years in the guidelines alone. But as you mentioned, a judge could go higher than that and is unlikely to look at some very grueling testimony that we saw lightly. And that could really count against her, and especially considering this long-awaited reckoning of the Jeffrey Epstein saga, and that multiple witnesses viewed her as Epstein's number 2.
Yeah, interesting, Adam. Let's talk a little bit about while this trial or the jury was deliberating, and I got to be honest, I was one of these people. I've prosecuted a lot of cases, and I got multiple days that are going on, and this comes down to a credibility call, essentially. I always said that. It comes down to, they may find little inconsistencies here and there, but if there's a general theme and these jurors believe that these women are telling the truth, she's going down. But days went by, and then they started asking for readback of all the testimony of the victims, which gets you unnerved as a prosecutor because you're like, wow, did they not understand the case? And then they started asking for reinstruction on the law. Did you sense that prosecutors got a little nervous while that was going on prior to the verdict?
I got the sense that Ghislaine Maxwell's attorneys seemed to be happier the longer that this went on, and one can only gather that the prosecutors had been on edge. You know, of course, I'm not privy to their conversations. They seemed very cool, calm, and collected in the courtroom when I witnessed them. But as you said, this looked for a long time, this could have come down either way. This was a jury that was scrutinizing the evidence very detailed and in-depth for 6 days. And as a matter of fact, that very morning had requested to look at the testimony of the defense's key expert witness, who was called to undermine the memory of the victims. This was a jury that did not tip its hand until that verdict was read. And that verdict, of course, was 5 out of 6 counts of conviction on very serious charges.
So, Adam, Ghislaine decided not to testify. One, is that a mistake in your mind based on this case? I know it's hard to predict, but I will ask nevertheless. And she seemed rather confident, people are saying, in the courtroom with that decision and with how the case went in. How did she look afterwards?
Well, let's put it this way. Ghislaine Maxwell, the last time she decided to testify or was compelled to testify in a deposition in civil litigation with Virginia Giuffre, she had 2 perjury counts charged against her. And those perjury counts, by the way, are still pending. They were severed from the cases, from the questions that the jury was considering, but they're still out there. So would things have been different if only she took the stand to testify in her defense? Well, you know, if past history is a judge, it could have been more disastrous for her. Perhaps this was a guilty on all counts if she subjected herself to quote, too tough questioning from very strong prosecutors who built a very powerful case. So it's very easy to imagine it going differently. Perhaps acquittal on different counts, but perhaps she would have lost on all 6.
Good point. So you've been speaking to a lot of attorneys and experts out there. The defense has vowed to appeal, which is not surprising that they would say that. The likelihood of a successful appeal on real issues, Adam, and also there is that 2255 motion. They file, a lot of prisoners file, which is ineffective assistance of counsel against their attorneys. What is the relationship with Ghislaine and her lawyers? Do you anticipate she'll wind up turning on them at the end in order to save herself, trying to argue that they were ineffective?
Well, I think that would be a very long shot motion if she would ever even contemplate that. Let's put it this way. She had very zealous, very experienced, very competent counsel, which is part of the reason why we had 6 days of deliberation, because she had attorneys who scrutinized every bit of evidence in a case spanning a quarter of a century. They examined every civil filing by every victim who testified on the witness stand and scrutinized all of their interviews with the press and tried to ferret out any inconsistency with what they might have told an FBI agent at any time in the past that has any sort of discrepancy with what they told jurors on the witness stand. And in a case that involves very old memories, these were very zealous attorneys who worked very hard to raise any shadow, any specter of doubt in favor of their client. The jury scrutinized that very carefully, and she lost. She lost very emphatically on 5 of those 6 counts. So if that were ever to be a consideration, I don't think anyone would say Ghislaine Maxwell got anything less than a fair shake in federal court.
Adam Klasfeld, the managing editor of Law & Crime Network. I want to, Adam, thank you not only for the accuracy of your reporting, but the articulation with which you reported. It was very, very helpful to us. And Happy New Year to you, Adam.
Thank you very much. Happy New Year to you as well.
Okay, very good. All right, we're going to take a quick break here on the Law & Crime Network. We'll be back with more. Please stay with us.
I'm Sean Stix Larkin, and you're watching Law & Crime.
Hey, you. Ever
Ever wanted to learn a new language but thought it'd be too difficult or time-consuming? What about French, Spanish, even Norwegian? If so, it's time to try Babbel. Babbel lets you customize how and when you learn. From quick 10-minute lessons on words, phrases, and grammar, to games that keep it exciting. Listen to a podcast on the go, or take a live online class with a real teacher. It's really up to you. Babbel's conversation-based technique was created by experts. They know a thing or two about what works. In no time, chatting about real-life topics will feel, well, effortless. So go ahead, see where Babbel takes you. More ways to explore, more ways to learn. Start learning today at Babbel.com.
I love Made In. I love what Made In represents. With the product, you could tell that there's extreme craftsmanship.
You would think a pan is a pan until Made In came along, and I went, wow, these things are something better.
I use Made In both at home and here at Craft in New York City. They're beautifully made and will help you take your cooking to the next level.
Those are the pans that we use at Alinea. We're going to have the best pans in the world at one of the best restaurants in the world.
We all have the strength to see what's possible. It's up to us to unlock it. Tonal, be your strongest.
Engaged, but not sure what to do next? Plan your whole wedding at Zola. Start with venues and vendors near you. We'll find ones that fit your style and budget. Then explore Save the Dates. Enjoy free personalized samples and free change the dates just in case. Add a free matching website to keep guests updated. You can even host virtual events on it for free. Build a registry that lives on your website too. Fill it with gifts, experiences, even cash funds. Start planning from home at Zola.com.
Did you know gravity and relativity were discovered by people working from home? Do you know what I discovered? Kale. Curly, dinosaur, red Russian, ornamental. Instacart opened my world to all kinds of discoveries. I discovered organic, wild-caught, vegan lip gloss. I discovered this, that, these, and I'm just getting started.
Instacart. More stores, more to discover. Visit instacart.com or download the app to get free delivery on your first order.
Do you have a box of videotapes, film reels, or photos that are degrading? Legacy Box professionally converts them to DVDs, thumb drive, or the cloud. Legacy Box is simple and safe, with over 500,000 satisfied customers. Visit legacybox.com today.
All right, Elizabeth Holmes, we are in day 7 of jury verdict watch here. This was a trial that lasted for 4 months. The founder and CEO of Theranos accused of wire fraud and a number of other offenses that deal with defrauding customers, patients, and doctors with regard to the blood testing capabilities that she had. She was on the stand for 7 days, partially blamed her boyfriend, who was the chief operating officer of the company, during her testimony. And as I've indicated, we are on day 7, waiting to see where this jury is going to come back. So far, the jury's only basically asked 2 things. They want to take the jury instructions home with them, and they want to replay a 2013 interview that the defendant had given with respect to her dealing with prospective investors. I have with us Bob Hille and Karen Nance. Karen, let me start with you. What do you make so far? Jury kind of quiet here in terms of giving any kind of blink, and it's a long trial. She testified for a long time, but the deliberation is getting a little long as well. Thoughts?
My thoughts are that she is an exquisite interviewer. She's had that experience over the years. And so her presentation on the jury was something that they're grappling with. Is it somebody that they can, it's not our typical defendant that's not used to being in the public, not used to testifying. And here we have somebody that has tons of experience. She's a very sympathetic defendant in that she appears well. It's clear that she has a child. And so there are a lot of things in terms of empathy and sympathy that we're looking at. She's brilliant. And so I think that unlike most of the cases that we discuss here and that are before us today, is that this is not a criminal case. So we're looking at loss of a lot of money. Potentially, this could have been catastrophic for people that if in fact Theranos had gone forward and people relied on this device to test whether they had these specific ailments, that would have been very tragic. It didn't happen. Luckily, we didn't get that far. So I think that the grappling is, we're the people that the primary people that invested. Were they savvy enough, or they should have been savvy enough? And was there deliberate intent on her part to deceive? And I think that's what they're grappling with, and that's why they're still out.
Bob, I mean, part of the evidence in the case is that she was taking banners or the graphics of pharmaceutical companies and making it appear to investors and others as if they were actually endorsing her product, which turned out not to be accurate. I think that was a very damning part of her testimony. Nevertheless, others have said she comes off as a very charming, to Karen's point, smart, articulate person. Is this a criminal case in your mind? You're used to dealing with complex litigation, or is this more of a civil case? Is that potentially what the jury's wrestling with?
Well, I think the length of time with the deliberations underscores why these are generally civil cases with a lower threshold for a burden of proof than beyond a reasonable doubt. So, I think actually the jury questions taken in tandem are very interesting because, number one, they wanted to look at the charge, take it home, and then they wanted to replay the recordings again, which is really the central aspect of this case. Did she know at the key moments of time in the case, because there's a lot of questions about when she knew what and what was said, but did she know at key moments in the case that the information she was generating was false? I think there's some big questions on that in the evidence in the case, and that when she communicated that, she intended to defraud and induce these investors to give reliance. Now, the problem with that is if these investors are savvy investors, as you pointed out, and they're investigating the company, they're talking to other people. They're not just relying on Elizabeth Holmes. So I think that the fact that the jury wants to go back to the 2013 recording and look at it and say, look, are these things she really believed? Or was she in a state of denial, or hoping that, okay, we're in trouble here with the way some of this is working out, but we got to fix it and I got to buy us some time, which is different than saying this thing is crashing and burning. Let's grab some money from these people and take it and run. So, that may be what the jury's struggling with.
Karen, you alluded to her savviness, if you will, and her communication style. So we've talked so much about this critical decision as to whether a defendant should take the stand. As prosecutors, we love that. We're like, lions in a cage, wait and get out, to get to that cross-examination. But could this be the one-off here? Could this be the person that was able to pull it off or sympathize with the jury or grab some sort of emotional connection with the jury that could at least at a minimum cause a mistrial? Is that what the defense you think was doing here?
I believe so. As I indicated, she has had her face in the public eye. She has been in a position to answer questions years and years and years, and she's extremely intelligent, and she's a very likable person. She appears well, she presents well, and I believe that the jurors are going to be swayed by that. She has a very soft appearance, and I'm, as a woman, I'm not really supportive of making judgments based on people's appearances, but the reality is that's what the jury looks at. If you present well, if you're empathetic, and this jury, I believe, is 8 men and 4 women. So I think that she has that appeal, and that people are not going to want to put a mother in jail who has a small child at home.
Yeah, we talked about, Bob, jury nullification and the principle in the other case that we're covering today, where 3 jurors didn't want a black male to spend the rest of his life in jail and try to bargain down to a manslaughter. You certainly don't have the gravity of that kind of crime here. What does 7 days on the witness stand mean to you? Is that because she was doing a great job for the defense, or was the prosecution grabbing at straws trying to cross-examine her to try to get her to some admission, and was it successful?
Well, that can backfire, having a witness on the stand too long, for a couple reasons. Number one, in some of the cases where, personally, I would watch the jurors' reactions that, okay, we get it. You can see from their faces, which is interesting in the days of COVID, to try and monitor that. And the other part of it is, though, so you can turn them off, which is bad because you may be getting to a point you want them to listen to and they're not listening to it. The other point, though, that I think is a problem is if she weathers the storm well. And remember, I think at least, the jurors identify with the witness more than they identify with the lawyers in any case. So they're going to look at that person, they're going to assess it. And I think going back to what Karen said, it was great points. Does this woman look like a criminal? Or does she look like she was doing what every other person does that's trying to make money on Wall Street? And so, or is there something different about what she's done here that is than what everybody else that's in business is doing, that's out there making money and telling how great their products are, from Tesla on down, So I mean, and there are mishaps with technology, and it can happen. But does that mean that if you think this is a great product, that you're committing a crime because it turns out not to be? So I think that that's what the jury's wrestling with, and I think that's why it's taken so many days to figure this out.
Karen, do you think that the fact that she's a woman who had a billionaire company was profiled as being, one of the greats, that some of this will come up, that if she had been anybody else, she would not have been prosecuted? To Bob's point, other successful people puff and kind of exaggerate certain things, but why her?
I believe that it can be a double-edged sword. She was said to be the next Steve Jobs, and her brilliance is clear from everything that we've seen, all the video interviews and her presentation. They're impeccable. So I think that we have both ways of looking at it. I think you can say, why is she, as you indicated, is she being singled out? Because there have been plenty of men who've done a lot worse and have taken a lot more money and have left a lot more people destitute because they were relying on the representations of this male individual. Right. So people can say she's being singled out. So we shouldn't go forward with this case because she is being singled out as a woman.
We have really, really interesting dynamic, I'm sure, that's in that jury room right now, but I should have an answer relatively shortly. So we're going to take a quick break here on the Law and Crime Network. Don't go anywhere. We still have a lot more to discuss. We're going to be right back. Thank you.
Holiday party season is finally here. JustFab's VIP membership gives you a huge selection of festive boots, booties, heels, and more. And of course, every pair is so comfortable. Head to justfab.com for 2 pairs of great shoes from just $29.95.
BarkBox isn't just a monthly delivery of dog goodies. It's a passport to a whole new world with toys and treats from a different theme every single month. To start your dog's adventure, go to barkbox.com.
A band of brothers, reunited after 30 long years. You've been verified to search for the ones you miss. You might just find what you've been missing all along. Been verified, no better.
2 out of 3 guys experience hair loss by age 35. Kinda scary. That's why I use Keeps. Keeps offers clinically proven treatments, and the sooner you start, the more hair you can keep. Get started for $1 a day at Keeps.com.
You may think every weather app is the same until you see WeatherBug over-deliver on so many layers. With millions of 5-star reviews and more free map layers than any other weather app, WeatherBug warns you with local winter weather alerts, keeps you prepared with hourly rain and snowfall rates, as well as real-time and future radar to track winter storms, plus road conditions, routes, and cameras for your commute. Don't get caught unaware and out in the cold. Be prepared with WeatherBug. Used by over 10 million and counting. Download the WeatherBug app today for free.
There has never been a better time to join AARP. This special offer gives you exclusive access to hundreds of AARP discounts, programs, and services that will add real value to your life. As a member, you can get discounts on glasses and eye exams, save on prescription drugs not covered by Medicare, but you can also save on travel, hotels, online movie tickets, restaurants, concert tickets, and so much more.
I didn't know that.
AARP helps members access exclusive benefits like Medicare supplement insurance, even auto insurance.
We can use that.
AARP offers financial tips, career resources, and tools that may help you avoid identity theft and scammers.
That's good to know.
Pick up the phone now to join AARP. 1 year for just $12. That's 25% off the regular membership price. You'll even get a second membership included free. And you'll receive AARP the magazine filled with information and articles important to you. Plus, you'll get hundreds of benefits and an additional free gift if you call now.
And you don't have to be retired to join AARP. You can join at 50 for instant access to many member benefits. For 60 years, AARP has fought to protect your Social Security, Medicare, and more.
That sounds good to me.
Now you know how AARP helps people like us take on today. So don't miss your chance to join now.
Call or go online now to take advantage of this special offer. 1 year for just $12. That's a savings of 25% off the regular membership price. And you'll get a second AARP membership for anyone in your home free. And get a full year subscription to AARP the magazine filled with information and articles important to you. Plus, you get the AARP mobile app that connects you to local events and activities near you. And as a free gift, we'll include this insulated trunk organizer. So don't miss this chance to save 25% and get 1 year for just $12.
Call 1-800-719-3847.
You're busy. Very, extremely busy. Busy dealing with dinner. Busy dealing with work.
I'm sorry, can you repeat that?
Busy dealing with just life. With no time to shop for the stuff you need. So you use Instacart. Because why wouldn't you? Just tell your Instacart shopper what you're looking for, and they'll bring it right to your door, fast. It's like having another you.
What were you saying?
For those days when just one of you isn't enough.
First one.
Visit instacart.com to get free delivery on your first order.
I'm Brian Ross, and you're watching Law and Crime.
Welcome back to Law and Crimes for the Record. My name is Bob Bianchi. If you're just joining us, welcome and Happy New Year to you. We have a lot on the plate. One of the cases that we're discussing today is Chandler Halderson. This is an individual who is accused of killing both of his parents, dismembering them, and scattering their body parts. He was initially charged with misleading an investigation, a missing persons investigation. He is now charged with first-degree intentional homicide. Jury selection is underway in that case. We also have Google searches that were recovered and phones that were secreted in various places that the prosecution is arguing shows a consciousness of guilt. So during part of this case, there was a contentious bail motion that was handled. The defense trying to get the defendant out on bail. Not only does the defendant want to get out on bail, but it helps the defense attorneys better assist that client because it's very difficult representing somebody inside the jail. Let's listen to a little bit of the prosecutor's take on the defense's motion.
Your Honor, first off, I hope you've I don't know if you've had a chance to read the criminal complaint. I realize it's quite lengthy and it was filed right around the 1:30 time. I was hoping to kind of limit my comments for the privacy of the family and others involved, but I'm happy to speak more at length if Your Honor wishes. The state is asking though for $1 million cash bond. Should the defendant post, we'd ask for GPS monitoring, a ban from any weapons, a ban from living in any household where any sort of firearms are kept, a ban from the Oak Springs Circle in both DeForest and Windsor. It's kind of an odd street where one side of the street is DeForest and the other side is Windsor. Additionally, that if he does post, that he stay at whatever residence he is staying at for 24 hours a day and be on house arrest. Obviously, these are very serious and very violent charges. And more charges are expected as the investigation develops. We know in this case, and it is outlined, or at least some of the instances, not all, but some are outlined in the criminal complaint, where the defendant has taken steps to both destroy and conceal evidence, including human remains that were dismembered. Because of the vast steps that this defendant has undertaken to hide his crimes and the broad spectrum of lies that the police have uncovered, there's substantial concerns about his willingness to come to court. And thus, $1 million cash bond really is the minimum amount of cash necessary to ensure his appearance. I certainly can give Your Honor more details if necessary.
Hi, joining me today all day long has been Karen Felecia Nance, as well as Bob Hille, both trial attorneys. I appreciate their commentary very much. Doing a great job, guys. Karen, let me go to you on this. What is your overall look at this case? When you're reviewing it, I always ask this question this way. I used to do it when I was prosecutor. Would you rather be on the prosecution side if you want to win a case, or would you rather be on the defense side if you want to win a case from what you know so far?
I think it depends on the case. And in this particular case, the prosecution appears to have a stronger case. I'm not sure what direction the defense is going to move in. My understanding is that there's going to be a potential of 300 witnesses, and they're going to be the names and the identities of those people are going to be kept private. That's the request. So it's interesting to see how that's going to proceed. But I believe that the prosecution, just from the information in the counts that are charged, have a very good case. And it points to the son as the perpetrator and the person that committed these offenses. So that would be at this point, I would be on the prosecution side.
Okay, well, we'll reserve your right to change your opinion as the evidence comes in, of course. This is what we do. We're in the cheap seats now rather than being in that arena fighting it out. And I know that could be very daunting. I've tried many cases where the media is reporting about it, and you're like, are they in the courtroom watching what's happening here, as opposed to the way they report it? But if you, Bob, let's play the game. If you want to win a case, you had to either be the prosecutor on this case or the defense lawyer. What side are you choosing right now based on what you know?
Well, I think right now I'd have to agree with Karen. I think, I'd rather be on the state side than the defense in this case. It's going to be a difficult one because, what reasonable alternative than the defendant is going to be established here? But again, we don't know a lot about the forensics and the circumstantial, because that'll play a role together, because nobody was an eyewitness to these crimes. And, the state's going to have to focus on ruling out anybody that this individual, might want to point to. And again, of course, there was the statement he made that somebody was supposed to pick his parents up and take them to a cabin. I'm sure that's going to get a lot of play in this trial, probably from the defense.
Bob, you raise a great point that when I used to conduct and run these investigations, is that even if you make an arrest, follow down the possibility of every other suspect so that you don't give the defense the opportunity to say you jumped to a conclusion and didn't look towards anybody else. And that kind of eliminates that. We'll see how well law enforcement did with respect to that principle of investigations. Anyway, the defense had an opportunity to argue the bail hearing as well. Again, hotly contested because the defense obviously wants their client out. Let's take a listen.
Well, thank you, Your Honor. We were in court on July 12th in this case, a series of charges, rather. And I made a bail argument then. The state requested $1 million cash bail, and a $10,000 cash bail was set by Commissioner Frengen. At that time, my client had been in custody and remains in custody since his arrest on July 8th. And now here we are, July 15th, and we're seeing actual criminal charges for the first time. When we were in court on the 12th, he had been booked into the jail mainly or only on in relation to what is now charged as count 2. But it was clear that it was contemplated that the other charges would be happening. They simply weren't written into the jail system. As soon as the $10,000 cash was ordered, it became almost a farce, because immediately some authorities went to the jail and then added the rest of these charges that you see here today onto what was holding him in the jail. And I guess under the theory that just buys them more time, where he can't post bail, doesn't have access to bail, even though we appeared and bail was set in relation to the events we see here. So he's had no meaningful opportunity whatsoever to post bail since his arrest on the 8th of July, because the minute we got a bail that was reasonable, the state immediately put another hold on him for the charges they were already investigating. I would note that almost the entirety of this criminal complaint talks about investigation and activities that would have predated that July 12th initial appearance date. And so I have to pose the question, why did it take so long? Why was he held in jail this long without any meaningful access to bail? But pivoting away from maybe what some might consider technical legal arguments that may or may not have merit depending on your point of view. I would reiterate what I said on the 12th, which is Mr. Chandler Halderson, sits here today with no prior record, a lifelong resident of the state, a high school graduate involved in many activities, such as Boy Scouts, church groups, school activities, the things that show he's been a problem-free part of this state and this community. Moreover, Mr. Halderson would agree to conditions such as electronic monitoring, the curfew as suggested by the state, whatever the court would deem appropriate.
Bob Hille, why did I get the impression that when the defense attorney was making that argument that he was on bail for another offense, and as soon as he was able to make bail, they filed the upgraded charges, that the prosecutor was kind of looking like, yeah, and what? So why? What did you think of the argument of the defense there?
Well, it was valiant, but the real issue is he a flight risk? Is he a threat to the public, given the nature of the charges? And there's no prior history or church group involvement, overcome that. I mean, I don't know that Lizzie Borden had a prior record, but, I don't know that she was out on bail. So, I think that in this situation, because of the nature of the charges, the court is within its rights to set bail with conditions, because bail was set here with conditions that if he were to make it, he had to comply with. But, he wasn't denied bail, but bail was imposed that was sufficient in the court's eyes to make sure he shows up for this murder trial.
Karen, not saying that the defense didn't make a good argument, and sometimes you dance with the one you brought, and you got to say something. But did you get that sense that the prosecutor was like, oh, and so we upgraded the charges and we're asking for an upgraded bail? Anything unusual about that to you?
Nothing at all. And we don't have any family members or friends speaking up for the defendant and saying, oh, he's not a flight risk and we'll take full responsibility. That's pretty telling as well. And so I think that the defense is stuck with their client being in custody. And I don't know if they're doing video interviews in light of COVID in terms of the interactions with the defense counsel and their client. That's probably going to be pretty tricky. So I do think that maybe the approach should have been to argue that they want to have access to their client and that being in custody causes some hardship. Or they probably just said, well, let's not even bother with that at this point. But that's going to be a challenge in terms of coming up with a good defense for their client.
Yeah, Bob, I think we need to nail down. We keep saying, generally speaking, it's difficult for somebody to represent somebody in jail. But talk to us a little bit about what that really means. I mean, everything between the scheduling and you go there and the jail's on lockdown and you got to turn around, or you finally get in and they got to have lunch and that's it. You only get an hour or two, or COVID protocol. I mean, talk about the significant depreciation of your ability to defend somebody in a jail.
Well, it chops up the ability to work with your client. I mean, as Karen pointed out, obviously the privacy issue is a problem because you don't have that privacy protection you would have in your own law office, meeting with a client, going over the case, and you don't have that uninterrupted ability to review evidence, go over evidence, discuss, how the response is going to, or what the response is going to be to that evidence. So, it is limited. And as I mentioned before, I said the other things, extraneous influences, which could be that, this person makes the wrong comment to someone in the jail, even not a wrong comment. Somebody makes something up to get some sort of a benefit themselves. And then they say, oh, yeah, he told us he did it. Or that he does write something incriminating and send it off to somebody, then I think, those things don't happen when your client, for the most part, when your client is out and you have free access to your client.
Okay, excellent point, guys. Appreciate it. All right, we're going to take a quick break here in the Long Crime Network. We'll be back with more on the other end. Please stay with us.
Have you ever wanted to learn a new language like French, Spanish, or Russian, but thought it would be too difficult and time-consuming? Then go to Babbel.com and try it for free. Babbel works because it's built around real life. It teaches you everyday practical conversations that you will actually use. In 15 minutes a day, you'll be on your way to speaking a new language in just a few weeks. Babbel uses a modern conversation-based technique that makes language engaging, fun, and memorable. It starts by teaching you words and phrases. Then, sentences gradually get more complex. Soon, you're practicing short conversations about real-life topics. Babbel is created by language experts who use the spaced repetition method to help you learn quickly and remember what you learned. With Babbel, you can speak a new language because language isn't just about learning new words. It's about learning a culture, a mindset, and a new point of view. Babbel, language for life. Go to Babbel.com and try it for free today.
Calibrate is a doctor-guided weight loss program that combines virtual doctor visits, FDA-approved medication, and one-on-one video coaching to reset your metabolic system. Get back in control of your weight and your health with Calibrate. Sign up today at joincalibrate.com.
Letting go of my diamond ring was really hard, but selling it for the best price was simple with Worthy.com. They evaluate your jewelry to help you understand what it's actually worth. Then they auction it to their network of professional buyers. Get more for your jewelry with Worthy.com.
Hello, I'm Mike Lindell, inventor of MyPillow. Thanks to your support, you've helped make MyPillow become one of the fastest growing companies in America. Over the last 12 years, you've helped MyPillow create thousands of jobs right here in the USA.
When I got MyPillow, I'm asleep almost immediately. I stay asleep at night and I wake up more well-rested in the morning.
That's why I invented MyPillow. My patented fill adjusts to your exact individual needs and helps keep your neck supported and aligned. I'm interrupting this commercial right now. Retailers have canceled MyPillow, and to thank you for your support, I'm going to pass the savings directly on to you. Go to MyPillow.com right now to get deep discounts on all MyPillow products. For example, you can get my premium MyPillows, regularly $69.98, now just $29.98, the lowest price ever.
For the best night's sleep in the whole wide world, visit MyPillow.com.
10 years ago, we started Legacy Box. If you're like us, you have a box of old videotapes, film reels, and photos just degrading away in your closet. Legacy Box saves these memories by professionally digitizing them on DVD, thumb drive, or the cloud. It's easy. Load Legacy Box with your media, and you'll get back your originals and new digitized copies. Legacy Box is simple and safe with over 500,000 satisfied customers. Preserve your memories today. Visit legacybox.com.
I'm Sean Sticks Larkin, and you're watching Law and Crime.
All right, we have breaking news on Colleen Maxwell. Apparently, the jury has sent a note to the judge indicating that they cannot come to you. Elizabeth Holmes, I apologize, cannot come to unanimous verdict on 3 of the 11 counts. 3 of the 11 counts. Presumably, they have come to a unanimous verdict with respect to the other counts. We're waiting right now to make a determination as to what the judge is going to do with that. Typically, what's going to happen right now is the lawyers are going to confer with one another. There'll be decisions as to whether or not to take a partial verdict, not take a partial verdict. The judge ultimately will make the call, whether to tell them to go back in and either finish it out or take that partial verdict and ask them to go back in and see if they can resolve the rest. We don't know right now, but when we find that out, we will let you know. Again, Elizabeth Holmes, the jury has indicated they cannot come to unanimous verdict on 3 of the 11 counts. Wow. We'll talk about that a little bit more, I am sure. So anyway, going back to the Maxwell case, we had an opportunity to have Sierra Gillespie from the Law and Crime. She's a network, she's a reporter, interview Adam Klasfeld, as you know, who is the editor at the Law and Crime Network, who was our eyes and ears and on the ground during the entire course of that trial. Let's listen to a little bit of Sierra's interview with Adam, and we'll talk about it on the other end.
There were 6 counts. The one count of acquittal was enticement of a minor, and it related to the story of Jane. Now, here's the interesting thing. There were 2 counts that related to the testimony of the victim who was testifying under the pseudonym Jane. Maxwell was convicted on one and acquitted on the other. So insofar as did the jury believe Jane, The answer is clearly, at least in part, yes, they did, because she was the sole basis that they could have convicted Maxwell on these 2 counts. We know that this was a jury that was very methodical about their approach to the jury instruction, a 80-page document. They were looking not only at the facts, but the arguments about the law. They asked for the definition of enticement, which was behind multiple counts. They asked for what certain jurisdictional issues would be. So we don't know. Only the jury, should they choose to come forward at some point, can conclusively say what happened. But it's quite possible that they found that prosecutors had not met the burden of proof on the law. They could have had a different view of what the legal bar to convict on that count was. But it seems clear, based on the verdict, that essentially, to simplify it, they believed the women testifying before them. They believed Jane. They believed Carolyn, who was the sole person behind the 6th count of sex trafficking a minor. And then there was the testimony of 2 other women, one testifying under the pseudonym Kate, and the only victim who was testifying under her real name, Annie Farmer. They were behind multiple other counts that were found guilty. So this was, whatever the dispute was on that count 2, it is clear from the verdict that this was a jury that believed the women who testified in front of them.
Yeah, Karen, Adam had given us an interview before about how thorough the lawyering was in this case, how good the judge was, and the attentiveness of the jury. Talk to us a little bit, even though the jury took a long time to come back, how difficult is it for the defense to be able to combat 4 separate women coming in, giving essentially the same kind of testimony with respect to the grooming and little details of things like they're very consistent, even though the defense brought out some inconsistencies? How powerful is it that these 4 women are all basically testifying to the same thing?
I believe it was extremely powerful. And I think that when the photographs were introduced, which the defense wanted to keep out, that showed the type of relationship, the intimacy between Maxwell and Epstein, I believe that probably sealed her fate, because it showed that she clearly had a very intimate relationship with him. And based on that, maybe the jury made the conclusion that she was an enabler in this particular case, and that she, as I believe one of the witnesses described as head of the household, as the woman that was in charge of what was going on, the comings and goings of that household for this period of time, and that she could not have been in a relationship with him and run that household without knowing what was going on in that household with these young impressionable young ladies. So I believe that the jury maybe had been on the fence, but the pictures, I think, sealed her fate.
Bob, talk to me a little bit about your insights as to what, when Ghislaine Maxwell is sentenced on this, which is, I believe, going to be a considerable sentence. What does her prison life look like?
Well, she's 60 now. She's been incarcerated, I guess, since 2020 or 2019, somewhere around there. So, there's federal court guidelines, as you mentioned before. So she's looking at perhaps the rest of her life in prison, if this conviction stands on appeal.
Yeah, and Karen, to the point though of how her day-to-day goes, in the prison system, somebody with this high level of profile, the background and environment that she grew up in, what she's used to in her life in terms of money and getting anything she wants at any particular point in time. How hard do you think her prison time is going to be for her?
Just the fact that she can't come and go, I think, is going to be very critical for her and very devastating. I know that her family is behind her 100%. They're arguing that the conditions there are horrible for her. I think conditions in prison are horrible, just the fact that for anybody, but they're saying especially for her. They claim that her health is not good. Her attorney asked, can she please have a booster to the COVID shot the vaccine while she's in custody. So I think when it comes to sentencing, all these factors, I think indicating that her health is not good probably will go in her favor in terms of how much time and where she's being housed, and the celebrity status that she holds will probably give her more leniency than, say, as someone that's been convicted of an offense that doesn't involve this amount of notoriety. I think that she'll get a break in terms of her housing status.
Yeah, well, I could tell you for sure that this is something that's going to be on any client's mind as to what their life is going to look like. And somebody at her level that has this affluence and this notoriety, one doesn't know how hard that's going to make it on her or not when she gets into in the prison, but it certainly will have an effect. I can assure you that. Anyway, Dayonte Resiles, an individual who was charged with a brutal and horrific murder of a woman, having tied her hands and her feet. She was found in a bathtub, stabbed multiple times, went to trial, was on murder, was found guilty, I guess you could say, of manslaughter. And I say, I guess you can say, because while the judge was polling the jurors at the end of the case, asking them whether they agreed with the verdict, one of the jurors said, no, I can't do this. It's not right. 3 of the jurors refused to vote for murder because they did not want to send a black man to jail for the rest of his life. The judge then told them to go back in and see if they can come to a conclusion and deliberate. They were unable to do that. A mistrial was declared, and the case is now back at trial again. The defense attorneys have made an argument in this case that double jeopardy should apply. She should never be tried twice for the same crime. However, the judge correctly ruled the verdict had not been finalized. This was to no fault of prosecutors or any of the litigants in the case, and therefore, since the verdict was not finalized, double jeopardy does not come into play. Bob Hille, let's talk about the physics of trials. I, as a prosecutor, personally, thankfully, I never had to try my own trial a second time, but I've had to try other people's trials a second time, and it never gets better for us because there's transcripts and testimony, but nevertheless, you work through that. What do you think right now in terms of the prosecutor's position on the case? Who's going to go steady pace wins the race, or are they going to change it up from the first trial?
Well, it depends on how strong they believe the evidence is going to play out a second time. It also is going to depend on whether they think that they can fix some of the holes that may have been there in the case. The interesting thing here is that the vast majority of the jury was leaning towards a conviction. So you didn't have, in a situation where you had one holdout or perhaps, 2 holdouts. But the real issue here too is a factor that's going to impact the integrity of the verdict has to be addressed with the court, and you have to eliminate that injustice, and that's going to require a second trial on this. What's interesting is now the court is alert to what that factor is. Now, where race raises a question as to the evidence and its reliability, that's a legitimate factor to take into account, and the state's got to look at that. But if it's not a factor, that's something the state really can't address in the retrial. But the court is going to have to really take a look at that to make sure that race, if it's not a factor in the case, doesn't enter the decision in the case. It's going to have to be careful in the jury it selects in that regard.
Yeah, Karen, this is just like really, again, we talked about this earlier, is one of these cases just surprises me. It's not like a George Floyd or Ahmaud Arbery, or one of these kinds of cases. I mean, this is a woman who was brutally murdered by a person, basically handcuffed and restrained and or tied, if you will, with her arms and her hands. How do you even possibly change your voir dire questions if you're a judge to get to whether or not people would not use race or try to get people not to use race, just to call it on the facts and law? How do you do that?
I believe that the prosecution and the defense are going to have to, in their questioning of the potential jurors, to address race, and to the extent that they can focus on only the facts as they're presented and get a buy-in from each of the potential jurors that, yes, they can evaluate the case without looking at the possible sentence. And I'm not saying that the prosecution and defense didn't do a good job of that in the first trial, but obviously there needs to be more work. I don't know what the dynamic of the jurors were, the racial makeup of the jurors were at the time in that case. We can assume that it may have been mostly Black, the people, the holdouts, but we have no idea. I think that would be jumping to conclusions. So I don't know what the makeup of the jury was. But I think that the other issue is the fact that when they came back and said they had a verdict, and then on the polling of the jury, we had some discrepancies. There wasn't 100% buy-in. That issue needs to be addressed and remedied for the next trial as well.
Yeah, really amazing thing. Like I said, I've only seen it happen once in court. It wasn't my case, and it's shocking, when that happens, because you expect they're going to come back. And people, a lot of times, guys, this, defense lawyers and prosecutors say, no, Judge, I don't need the jury polled. This is one of the reasons why you pull that jury. All right, guys, we're going to take a quick break here. For the record, we'll be back on the other end. Please stay with us.
I'm Dan Abrams, and you're watching Law and Crime.
It's okay to be curious. Curious about that person you met online. Is this someone I actually want to meet? I've swiped right. What's next? Come to Been Verified to help find love that's real. Been Verified. Be curious.
Okay. Billy is like the unicorn of razors.
The unicorn of razors.
The unicorn of razors.
I haven't been this smooth since I had braces.
My leg hair was coarse enough to braid, and this razor sailed right through it.
In one swoop, everything was gone.
It's like some kind of witchcraft. This razor is super sharp, and I shave everywhere. Obsessed.
No one can deliver your mom's homemade short ribs. That's why Instacart helps deliver the ingredients, and you add the love. Visit instacart.com or download the app to get free delivery on your first order.
I love Made In. I love what Made In represents. With the product, you could tell that there's extreme craftsmanship.
You would think a pan is a pan until Made In came along, and I went, wow, these things are something better.
I use Made In both at home and here at Craft in New York City. They're beautifully made and will help you take your cooking to the next level.
Those are the pans that we use at Alinea. We're going to have the best pans in the world at one of the best restaurants in the world.
They are some of the hottest videos on social media. Those videos claiming to instantly get rid of bags under your eyes. Annette Figueroa is here to tell us why she says this one is for real.
This one is for real, and I'm so excited. Not only does it work on the bags, it works on the appearance of crow's feet, fine lines, and wrinkles. We even have a video, and all he uses is a small amount, and that's how easy it is. And I did this to my father. We were at home. 4 minutes, 34 seconds, completely gone.
My real true opinion is holy words I can't say on camera. This is absolutely unbelievable. I mean, I could feel it just lifting my skin. It was amazing. It feels good. Feels great. Looks even better.
At our $14.95 price, it's the best way to try Plexiderm and see it work for yourself after your first application. Your solution is at plexidermtrial.com or call the number on your screen.
Want payday to come a little faster?
I get paid 2 days before everyone else. I love getting paid on a Wednesday.
Want to say goodbye to those long check cashing lines?
I can never see myself standing in a line at a bank again.
Get your own NetSpend prepaid MasterCard with direct deposit. Your money loads straight into your NetSpend card. Shop online, pay bills, buy groceries. Use anywhere debit MasterCard is accepted.
I use it every day for every purchase. I use it to pay my rent.
It's not a credit card. It's convenient, and you can even earn payback rewards on many of your purchases. That's money right back into your card account.
From eating at major restaurants to sending my mom flowers, I get cash back.
Because this is not a credit card, with NetSpend you pay no interest fees, late fees, or activation fees. There's no credit check to get started and no cost to order.
I use my NetSpend card for everything.
Be one of the first 200 callers and choose your card color. 1-800-866-0189. That's 1-800-866-0189. Get paid up to 2 days faster with NetSpend.
Everything you've seen me do was made possible by what you don't see. Because when you're not looking, I go to work. Strength isn't a given. It's grown. It's earned and tested. We all have the strength to see what's possible. It's up to us to unlock it. Tonal, be your strongest.
Welcome back to Law and Crimes for the Record. I'm Bob Bianchi. I'll be taking it to 3 o'clock. We have so much we've been discussing on the plate today. Crystal Daniels is another one of those cases. You may recall that the father of baby Joe, Joseph Daniels, was convicted of murder, where he is spending a 51-year sentence. We covered that gavel to gavel at the Law and Crime Network. Crystal Daniels' case is to begin next month. It's going to be a different kind of case. So it'll be interesting to see if the prosecution is going to have the same ability to be able to prove its case against Crystal as it was Joseph. In fact, part of this case is going to be interviews that were given during the course of the investigation. One of those interviews was with respect to Joseph Daniels, and the ultimate question being asked, because she's being charged with aggravated child abuse, is to what she knew or didn't know about this abuse. It'd be a critical, pivotal issue at trial. Let's go to tape.
How far into the field? Was there tall grass or short grass? Tall. Tall? Tall. It was tall grass. You know how far? It's about halfway through, maybe? Somewhere around there. Halfway into the field? Yeah. Was there a tree line on the other side? I know there's trees next to the car. There's trees next to the car, right? There's a field on the left. You know that curve right there where that little pond was? Yeah. Was your, let's see, let me pull the map. And you said the trees were to the left or to the right? To the right, the field to the left. Right, the field is to the left. Crystal says it'd be there. Crystal says what? So. As Crystal said, you know what Crystal was saying? Hold on one second. Okay, let me. This is important. Okay. So you're saying Crystal doesn't know any of this? No. She doesn't know right here. This curves, right? That curve. Yeah. Where you said there were trees to the. Where was your car facing? My car is here. The car would have been facing back. Yeah. Okay, and there were trees to the right. Yeah. Were these trees? Yeah. And how far down past this curve do you think you were? I know it wasn't facing all the trees, so it was somewhere around this area. Right here. Okay. Now there's looks like there's some trees here. You see them? Yeah. Was it before those trees? It was a little bit. It was maybe around here.
All right, Karen, here Daniel says that Crystal didn't know about any of this. She's being charged with aggravated child abuse. And she must have been a part of it in some way. Prosecutors are going to have to make that causal connection in order for her to be guilty of that kind of offense. Where do you think they're going to go with that? How are they going to prove it?
Listening to his interview, I think, is very helpful in that he did say she didn't have any information about that. Is there any motivation or incentive for him to lie about that? I don't think so. He's already in his situation where he's potentially at the point, he doesn't know this at this time, but he's going to get significant time. But there's no benefit to him to lie about her involvement and what she knew at the time. So I think that this is very helpful for her defense team for this to come out.
Yeah, so during the course of the trial against the father, Joseph Daniel's stepson, Joseph Daniel being the defendant, was present the night that baby Joe apparently peed on the floor and was subsequently killed He says that Crystal was there for that too. Let's take a look at that. Again, very pivotal testimony in this case.
I walked up halfway up the driveway whenever I first moved, then the rest of the way up the driveway. So second time I moved.
Did you go all the way to the road?
No, not all the way to the road. I stood at the edge of the driveway though.
Okay. And how long did you watch the defendant?
I watched him for a couple of minutes or so. Watched him walk down the road.
Could you tell how far he walked?
No. I didn't know meters, miles, or anything like that yet.
Were you scared of the defendant after he threatened you?
Yes.
After you saw him walk down the road, what did you do next?
I went back up the driveway.
And where did you go?
I went into the house.
Okay. What'd you do then?
I went back into the room and I tried to go to sleep, but eventually I went back to sleep.
Eventually you went back to sleep?
It was hard, but I did.
When you went in the house, where were Aunt Joyce and Noah and Crystal?
Joyce and Noah were sitting at the window, I think.
They were sitting at the window?
Yeah, I'm pretty sure.
Okay. What about Crystal?
She was probably back in her bedroom. I didn't see her.
You didn't see her?
No.
Okay. So when you went back in the house and tried to go back to sleep, did you go into your bedroom or Belle and Big Joe's?
Belle and Joe's.
All right. And what happened the next morning?
The next morning he told me to get up and that my brother had run away.
The next morning he told you that your brother had run away?
Yes.
Now, did you go somewhere with the defendant that morning?
Yes.
Where did you go?
We rode down the road.
Okay.
We got to the car. We rode down the road.
All right. Now, let me ask you just a few more questions and I'll be finished, okay?
Mm-hmm.
Were you supposed to go somewhere that summer with Crystal?
Yes.
Where were you going to go?
Kansas.
Kansas?
Yeah.
Bob, can we expect that the prosecutors are going to call this stepson to the stand in this case, and if so, why?
Well, it's going to be interesting because he puts the mother in the house, so he really needs that testimony to link her presence there or corroborate the evidence that they have that links her presence there. But what's interesting is he never really pins her to being in the location where his brother was, alleged to have been killed. So in that respect, concerning the charges against her, his testimony may not be very helpful, but he's going to be needed to establish what happened in the underlying matter and also with respect to the father and that she was in the house.
Yeah, Karen, there's a different kind of prosecution when you're prosecuting the person who at the hands of that person caused the death, as opposed to a party who did not literally cause the death, but you're trying to tie in as a prosecutor some mens rea or mental state. Each state says it differently, but it's basically the same, either knowledge or purpose, knew or should have known, becomes a little more stretched in terms of you having to use circumstantial evidence to prove that. Do you expect the defense will exploit that fact to say her mere presence at a crime scene does not make her responsible for the crime itself?
Absolutely. And I think that this witness, the stepson, is very helpful too, because helpful for the defense of Crystal, because he can indicate and testify that, look, she wasn't, as far as he knows, involved. He didn't know, Crystal didn't know anything about the whereabouts of the 5-year-old. And I think that also I believe that she's going to be a very sympathetic witness. I think that a lot of the jurors are going to have empathy for her. I don't think that at this point, it doesn't appear that she would need to testify if this extra testimony comes in. And I think that if the evidence or the insinuation that there was some domestic violence will support the fact that she may have been actually afraid for her life, which was included in the transcript. So I think that this would be very instrumental in helping with the defense of Crystal's case.
Yeah, I know a lot of people were saying after the conviction of the husband, or the father rather, I should say, that this was going to be the death knell for her. But they are two completely different kinds of cases for the reasons you just stated, Karen. All right, guys, we're going to take a quick break here on the Law and Crime Network. We'll be back with more on the other end. Please stay with us.
I'm Jesse Weber, and you're watching Law and Crime.
BarkBox makes it easy for me to spoil my dog. I just tell them about Coco, and they send original toys and treats all tailored to him, with fun new themes that we both enjoy. Every month. Make your dog happy with BarkBox.
Over 50 million in prizes paid, more than 4 million pounds lost.
I'm global health and fitness expert Jillian Michaels, and I love Healthy Wager. It's a great way to lose weight by motivating you with big cash prizes. Catherine, you won big with Healthy Wager. Tell us about it.
Yes, I won $2,094 for losing 98 pounds, and it was the motivation I needed.
Jillian, I lost 65 pounds. I won $1,285.
You guys did this as a team.
It was the diet plan that kept us right on track, and the money was a huge motivator.
Play with a free prize calculator and see how much money you can win by hitting your weight loss goals. Get paid in real cash up to $10,000. Diets alone don't keep most people motivated, but with Healthy Wager participants, they often lose 30, 50, 100 pounds or more. Healthy Wager is the ultimate solution, providing structure, accountability, and cash prizes for motivation. Everything you need to succeed, and you can win up to $10,000.
Healthy Wager works. I think Healthy Wager gives you the control you need so that you can feel empowered by your own efforts and what you're doing for yourself.
You're gonna lose the weight, you're gonna look and feel great, and win big cash prizes up to $10,000.
Healthy Wager has changed my life. I would highly recommend it to anyone that is struggling. You can do this.
Join Healthy Wager and jumpstart your weight loss with my custom workouts and meal plans. We have you completely covered. Healthy Wager gives you the motivation to stick with your weight loss plan.
I just think it's such a strong motivator to get started. I never knew that I could feel as good as I do now.
Guys, this is an incredible opportunity. You win, you get your prize.
Join Jillian's Healthy Wager and win up to $10,000. Act now and get 6 months free access to the fitness app by Jillian Michaels. Play with the free prize calculator at healthywager.com.
I'm in a work meeting right now, so I don't have time to shop for the perfect avocado. Sam, you're still on mute. Luckily, the shoppers on Instacart shop like me, so I can go to yoga class instead of hunting for organic toothpaste. Namaste. With Instacart, it's practically like I'm shopping myself. Ooh, nice hair.
Thanks. You too. Instacart. Shop like you. Without shopping. Visit instacart.com or download the app to get free delivery on your first order.
Do you have a box of videotapes, film reels, or photos that are degrading?
Legacy Box professionally converts them to DVDs, thumb drive, or the cloud.
Legacy Box is simple and safe, with over 500,000 satisfied customers.
Visit legacybox.com today.
Welcome back to Law and Crimes for the Record. My name is Bob Bianchi, and I have two great guests today, Bob Hille and Karen Nance. Guys, listen, I hate to say party is such sweet sorrow. I want to thank you for all the great commentary today. You guys are always awesome. Happy New Year to you. We have a special segment that's going to be coming up, but I really appreciate your time with us. So we're going to move along right now to Sierra Gillespie, one of our new reporters here at the Law and Crime Network. My first time doing a hit with her. Welcome to the club, Sierra. Great to have you. I know that you are following Wisconsin versus Chandler Halderson during jury selection. So just give me a takeaway right now. What's happening from your vantage point in terms of this really gruesome case and how the jurors and the lawyers and the judges are so far responding to this, what probably is going to be a difficult jury selection given its notoriety?
Yeah, so far, Bob, it seems that way, that it has been somewhat difficult given that this case has gotten a lot of media coverage here in the capital city of Wisconsin. As you know, Chandler Halderson is accused of the murder of both of his parents and dismembering their bodies. He's now facing trial for that. So a lot of the issues that we're seeing so far today are that jurors are coming in saying, hey, I already believe he's guilty. There's nothing you can do or say that would change my opinion based on that. A lot of them say that they have read about this case, seen news coverage of this case since this happened back in July. Several jurors, even today, were saying, yeah, I heard about it on the radio down here to the Dane County Courthouse that this jury selection was beginning today. So people are very familiar with the case, and that's kind of the issue that the defense attorneys and the prosecution are running into today. So actually what has happened is Judge John Hyland ordered that the jurors be taken separately, one by one, into another room. No cameras were allowed there. And basically he went through this morning and into the afternoon and asked these jurors, hey, what do you know about the case? Do you have any preconceived notions? Could you be swayed one way or another? And I would say most notably throughout all of this is that Halderson has just sat there listening to several jurors say, I believe this man is guilty. He hasn't really had much of a reaction, though. That's what I will say so far about the defendant.
Yeah, I was going to just ask you that. I always love to see what the reaction of the defendants are when people are asking or answering questions in the way they are. Well, so far, if you can see her, what's the demographic look like there? They have a mixed jury pool, men, women, minorities, things of that nature, or do you see kind of a little bit more skewed towards one demographic or another?
I would say there's been maybe 5 people who are minorities. By and large, most of the potential jurors here are white people, and most of them, I would say, are above age 30 and up. It's about 50-50, though, between the amount of men and women, but by and large, it is all majority white people here.
Yeah, Sierra, when the judge was reading the list of charges, and we were listening to that on tape, and talking about this really, horrible thing of dismemberment and abuse of a corpse, and of course, obviously the killing of one's parents, which I always found as a homicide prosecutor to be like the most unbelievable thing, right? I mean, you can always kind of put your arms around certain kinds of murders, but that's really just unbelievable. What were the jurors, or was there any juror reaction when they were listening to those charges being read?
So because this case is so widely publicized here in Madison, it seems by and large most people kind of came into it expecting that they were going to be called to the Chandler Halderson case. So a lot of them did have wide eyes, but it seemed that most of them knew what they were getting into. What I will say, though, is Halderson himself, as the judge was going through and reading all of these charges that are against him, he's pretty much stoic. He doesn't even shake his head, nod, anything like that. Occasionally he'll write things down on a legal pad in front of him or take a sip of water, but by and large, he's pretty much just sitting there accepting it. And based on the criminal complaint, we knew that investigators initially, when this happened, said that Halderson didn't have much remorse. So that's something of note here, too. He doesn't have much of a reaction to this, though some of the jurors do seem in awe by these pretty intense charges.
Yeah, and what kind of jury pool are we looking at? Do we know how many jurors the judge called up? Do we have an anticipation of when the judge thinks that jury selection will conclude? And how difficult do you think it's going to be to find this jury pool?
So I truly believe that the most difficult thing here is finding an unbiased jury. And that's got to be the way that it is in any trial. You know, people who come into this and say, I can accept the evidence as it's presented to me. I'm not going to have any preconceived notions. And again, we keep going back to the same thing. This is a highly publicized case here in Madison. So a lot of people have bias. And so far, the judge has dismissed, I would say, 10 to 12 potential jurors who either some of them actually knew people who were on the witness list. Other people lived nearby where Bart Halderson's body was found, and they were actually nearby the day that police and investigators were searching. So several people have already been eliminated because of those instances. Now, the judge did say at the start of the day this morning that he was hoping jury selection would conclude today. He is planning for opening statements to be set for tomorrow, but that could still change. We have no definitive amount of jurors that are selected as of right now. We're just finishing up the lunch recess, and then we'll head back in after that. But as of right now, who's to say what could happen?
Well, Sierra, now you open up Pandora's box. I'm going to have to ask you this question. If they're trying to get these jurors to go in there, are the lawyers given the opportunity of using peremptory challenges? And I never thought I'd even be asking this question, but the only reason I am is that there's been this big push around the country to eliminate or greatly limit peremptory challenges, which by all definitions, these prosecutors and defense lawyers think is a horrible idea. What exists there? Peremptories? No. If so, how many?
That is something I can't exactly speak to. I guess we're still pretty early on in the stages, so I guess I'm going to have to wait and see on that one. I don't have the exact answer for you there, Bob.
Okay, so let's look a little deeper into this scenario. I mean, obviously horrific charges that are being filed here. Any word from the defense lawyers as to whether they're seeking sequestration of these jurors, or at some point in time, because of the responses these jurors are given, that maybe this is the appropriate thing to do at some point in time during the phase of this trial?
I haven't heard any word yet about the judge or anybody asking for sequestering of the jury so far. What I will say is that as these jurors were brought into the separate room and, they were being questioned about the publication of the case, how much they sought it out, did they get alerts to their phones, things like that, really how much they know about the case. Pretty much unanimously, the prosecution, defense, and the judge, if anybody said, hey, I know somebody who is involved in the case, or even one person said that they worked at the high school where Chandler Halderson attended years ago. He's 23 now, as we know, but years ago, he attended that high school and she now works there. She said, hey, I don't know him, but I know people who do know him. And after that, all sides were saying, hey, this person, she may be a little bit too close to the case. We want to make sure that everybody who is a definitive juror is as unbiased as they possibly can be. So I think that's something that's kind of interesting in this case, that you are hearing a lot of agreement so far from the prosecution and the defense and the judge, and that they're all looking for jurors who are coming in with an open mind and not too much baggage here.
Well, I was just about to ask you, like, are they playing well in the sandbox or not? What are you seeing there with regard to the judge and defense lawyers and the prosecutors in terms of their relationship with one another? Are they going at each other? Do you anticipate tooth and nail, or are they going to do it professionally and just attack the case itself?
So far, things have been pretty professional. Like I said, it's kind of crazy to see the defense, prosecution, and judge all agreeing so far. There hasn't been any sort of conflict or yelling, or really they've been pretty respectful to one another if the prosecution were to bring up a point about a juror, or the same with the defense. So it's kind of remarkable to see that so far, though we haven't even heard opening statements yet. And I can only imagine what's going to come out during opening statements and whether people are going to be, going head to head at that point. But what I will say notably now, they are pretty respectful so far.
Sierra, we got about 20 seconds. Talk to me about the media coverage that's out there right now and its potential effect on the trial.
The biggest thing with the media coverage here is that Chandler Halderson came forward in July and he said, my parents are missing. He went to the 3 local stations here in Madison and did interviews with them. And what's notable about this is that they played when he was a missing person. A lot of reporters are actually even called as witnesses here.
All right. Sierra, I'm going to have to cut it there. It was great having you on the show. I really appreciate it, but we're coming up to a hard break. So that's it for us today, but don't go anywhere because we have the very capable Michael Bryant that's up next to take you through the rest of the coverage. Have a great week.
Every plate helps save you time and money on meals you'll love.
We have a high-pressure system moving in from the east,
so you can seize the day. Oh, no. Even if it's not ready to be seized. Live your best life with America's best value meal kit and get your first box for only $1.99 a meal. Plus, 20% off another 2 boxes using offer code EPTV199.
I'm Dr. Lakeisha Simmons. 4 years ago, I was a single mom and I was living paycheck to paycheck. That's when I downloaded the free Personal Capital app, and it changed my financial future. I linked all of my accounts and I instantly saw where I stood. I was able to track my budgets and spending and see how that affected my net worth. Now I use the retirement planner and I monitor my entire portfolio. 4 years later, my nest egg has grown and I'm ready to retire.
Download the free app or go to personalcapital.com today.
My Just Fab fall collection is high on style. Think runway fashion without the price and wear all day comfort. This is the return of fabulous fashion. Step up, step out, you're on.
It's okay to be curious. Curious about that unknown number. Who was that calling? Who keeps texting? What if it's actually important? Or an old friend trying to get in touch? For the next unknown number, use Been Verified. Be curious.
It wasn't Meta's fault that yo-yo dieting failed her.
Calibrate works with her biology to end an unsustainable cycle. Medication, coaching, lifestyle tweaks. Lose at least 10% of your body weight or your money back. Join Calibrate.com.
This is a paid advertisement for legal services from Clinton Black Law.
Welcome to our show, and thanks for watching. I'm Tony Noakes, and with me today is Dr. Wendy Walsh. Dr. Wendy, can you tell our audience what concerns are there for women who have used talcum powder?
Studies on the causal link between talcum powder usage and ovarian cancer date back as early as 1971, and more recent studies in 2013 published in Cancer Prevention Research. Now, with regard to the ovarian cancer risk, a Harvard researcher, Dr. Daniel Kramer, has estimated that as many as 10,000 women annually develop ovarian cancer as a result of the use of talcum powder.
You know, with all this disturbing information, have there been lawsuits filed against the manufacturers?
Yes, Tony, a number of these suits have already been settled. The largest so far was a July 2018 jury verdict for $4.69 billion awarded to 22 women that concluded that they developed ovarian cancer after the use of baby powder.
Dr. Wendy, that is some really important information for our viewers to be made aware of. Thank you. I would never have thought that talcum powder could be so dangerous. If you or someone you love has been harmed due to the use of talcum powder products, you need to call the number on the screen now, as you may be entitled to significant compensation for your injuries.
Have you or a loved one been diagnosed with ovarian cancer after regular use of Johnson & Johnson baby powder? You may be entitled to compensation. Substantial verdicts have been awarded against Johnson & Johnson because of their failure to warn the public of this risk, including a $4.69 billion verdict in July 2018 to 22 women and 3 other verdicts totaling over $614 million. If you or a loved one has been diagnosed with ovarian cancer after regular use of Johnson & Johnson baby powder, call now. This is a paid advertisement for Elstock, Whitcomb, Crease & Overholtz, PLLC.
I'm in a work meeting right now, so I don't have time to shop for the perfect avocado. With Instacart, it's practically like I'm shopping myself.
Instacart. Shop like you without shopping. Visit instacart.com or download the app to get free delivery on your first order.